Good morning. I'd like to welcome everyone to the Special Committee on Government Overreach and the Impact of COVID-19 Mandates. We will start this morning with an overview of exemptions from educational vaccination requirements in Kansas, Office of Revisor of Statutes. Welcome to the committee.
Thank you, Madam Chair, and good morning, everyone. You should have a memo in your packet from our office with some attached forms from school districts and universities in the state. This is just some follow-up information to the information provided to you at the last meeting about exemptions from vaccination requirements, this time specific to K-12 education and to higher education in the state. So first, we'll talk about K-12 education and vaccination requirements and exemptions that apply there. Kansas statutes do impose vaccination and other health requirements for children enrolling in schools and preschool and daycare programs operated by schools. The statute provides that the Secretary of Health and Environment may determine which tests and inoculations are deemed necessary for this purpose. The statute also provides exemptions from those requirements. Requires that a student requesting an exemption provide the school with either an annual written statement signed by a licensed physician that the required tests or inoculations that have been prescribed would seriously endanger the life or health of the student, or a written statement signed by one parent or guardian of the student that the student is an adherent of a religious denomination whose religious teachings are opposed to those tests or inoculations. As far as implementing this, the Kansas Department of Health and Environment does provide a uniform medical exemption form for use by the school districts. That is the first attachment behind the memo in your packet. No state agency provides a uniform religious exemption form. Some school districts have developed a form that they use for official purposes within their own district. Some other districts do not have a form, but do require a written statement from the student to claim a religious exemption. Again, some examples of those forms used by school districts. I think we have Shawnee Heights and Kansas City, Kansas school districts forms included in the packet for you for way of example. So the next issue is colleges and universities in the state and vaccination requirements that apply to those. This is even more limited than the provisions I just mentioned for K-12. The only provision in the Kansas statutes annotated specifically governing vaccinations in colleges and universities relates to meningitis. The statute requires that each college and university have policies and procedures in place for incoming students who are residing in student housing to be vaccinated for meningitis. Those policies by statute must include appropriate waiver provisions for students who refuse to take the vaccine. But unlike the K-12 statute, the statute for meningitis in higher ed does not speak specifically to the reason a student might refuse to take the vaccine, just has a general statement for requiring exemptions. Any other vaccination policies would be determined by the governing body of each college or university. And again, there are some examples of the forms used by some colleges and universities attached to your packet. I believe we have Fort Hays State, Pittsburgh State, and KU forms for you to review, for example. So, Madam Chair, that concludes the information I have on educational vaccination requirements. I'd be happy to stand for any questions.
Questions, Senator Warren, then Representative Owens.
Thank you, Madam Chair, and thank you for that summary. We have here the KU immunization history form in our packet. Is this for a medical exemption only, or would this apply to religious exemption as well?
So if you look on the back, it's the bottom half of the back of that page. It has an option for a medical exemption, temporary medical exemption, or religious exemption. So you'd use the same form for whichever reason you are claiming an exemption.
Okay. Thank you. Thank you, Madam Chair.
Representative Owens.
Thank you, Madam Chair. Looking at the religious exemption, as mentioned earlier for K-12, assuming that the written statement signed by one parent, adhering and following what is written there, is there then somebody at the school that decides if that is acceptable, Or is it just assumed if this statement is filled out that religious exemption is automatically granted?
So the statute doesn't really speak to discretion of the school district. It's pretty silent on that issue. The statute provides simply that if the student is claiming an exemption, they have to provide this written statement to the school district.
Okay. Thank you. Thank you, Madam Chair.
Senator Warren?
Thank you, Madam Chair. As I'm looking at the form that's been provided, I think I'm just looking at the last page of the packet, it's the KU one. I think prior days of the committee hearing that we've had here, we were talking about the religious exemption that KU was using. And the form, anyway, that's been provided in our packet relates to religious exemption to measles, mumps, rubella immunization. Do we have the one related to COVID-19 vaccination? It's not in our packet, but would that be something that research could provide?
We did not provide that in the packet. We can try and track that down for you.
That'd be great, because this would not even be something that would be used for the COVID-19 vaccination. Is that right? This wouldn't be, I mean, you're not a representative of KU, but it strikes me that this wouldn't be kind of responsive or relevant to what we're looking at here today.
Sure. So we provided this form specifically as an example of as it relates to the discussion of statutory requirements, which, as I mentioned, are only 2 meningitis vaccines.
Okay. Thank you. Thank you, Madam Chair.
Representative Owens?
Yeah. Madam Chair, just a follow-up, and maybe just for the committee's information, I'd really like to hear from maybe the State Board of Education on this issue, because I've heard from many of my constituents that they're concerned about COVID vaccines being mandated on school children. And so I would like to know if these religious and medical exemptions that we already have in statute are generally accepted to just, as long as it's filled out, it's accepted. That's the real question that I want to get an answer to see whether we need to address anything legislatively there. Thank you, Madam Chair.
Scott, as a follow-up to Representative Owens' question, is there any data on how many exemptions are sought each year through our educational institutions, either K-12 or higher ed? And if so, how many are granted or denied, and on what grounds? Is that data available?
I'm not aware of that data, but we can look into that for you.
Thank you. Senator Thompson?
Thank you, Madam Chair. KSA 38-141B says shall be the public policy of the state that parents shall retain the fundamental right to exercise primary control over the care and upbringing of their children. So don't we already have in statute some protection here that this just essentially is affirming those parents' right to say these children should not get this vaccine?
So I think it'd be a question of how those provisions of law interact, and I'm not really prepared to speak to that at this particular moment, but you would have to compare that to the provisions that I discussed that do impose those requirements specifically on school children and see which one controls in a given situation.
I guess what I'm asking is, are we now asking permission to give permission to protect the rights that are already in place? I'm all for doing what we can, but it's just like we've got these things in place to enforce. They should be enforced.
Again, I think you would have to look at those statutes kind of in harmony with each other.
Thank you. Thank you, Madam Chair.
Representative Barker?
Thank you. Thank you. Thanks for being here. You indicated that all of these medical exemptions, this is a form that was sent out by Health and Environment. Are they returned to Health and Environment? And is the statute silent on that? Does each agency keep their own? Because I'm looking at who's responsible, who's the keeper of the record, so that we could go through those and see ones that were approved and ones were not approved, to kind of look at if they're consistent. So is the statute silent? Is there no repository where all these exemptions are kept?
Yes, I believe the statute is silent on the issue of whether those forms get forwarded back to KDHE. The statute requires simply that the form be provided to the school district where you are requesting the exemption.
So we don't know the ones that were approved or disapproved.
Again, I don't know if there's a policy in place that they get those forms back anyway, but the statute is silent on that issue.
All right. Thank you, Madam Chair.
Senator Warren, then Representative Landwehr.
Thank you, Madam Chair. Thank you again. Scott, could you speak briefly? We have some public school, unified school district medical exemption forms here. I've had a lot of questions from constituents and Kansans regarding the interplay of the exemption form and current statute elsewhere. It's 65-129B, particularly subsection 1D. That you're nodding your head. Are you familiar with it? Or
Familiar? I may not be able to follow you along exactly without it in front of me, but yeah.
Sure, and I'm just wondering, with the current form of 65-129B, and it in essence says if on behalf of a minor child, a parent or guardian refuses vaccination, that the local health officer or the secretary may require the minor child to remain in a place of isolation and quarantine. Is that impacted by the medical exemptions that we've been looking at regarding COVID-19?
So again, I may not have all the details correct without seeing the statute in front of me, but I believe the statute you're referring to is more to specific findings of an outbreak or the general quarantine power of the local health officer or of KDHE. So there's kind of two separate issues at play. The statute I referred to in the memo, the general requirement that children who are enrolling in school for the first time be vaccinated against certain conditions. And then you kind of had this separate issue of if the local health officer or the secretary of KDHE is using their power under Article 1 of Chapter 65 related to quarantine and those other types of measures. I think you kind of have two separate issues that you'd have to analyze separately.
All right, thank you. Thank you, Madam Chair.
Representative Landwehr, then Senator Petty.
Thank you, Madam Chair. And this is not so much for you, Scott, as it is our research staff. If we could get the new religious form that I think our KU, K-State, Wichita State may have changed theirs, I think that would be good for us for deliberations later on. Thank you.
Senator Petty, then Representative Miller.
Thank you, Chairman. In our packet, the materials that you provided, and I'm looking at the one for Shawnee Heights. So the reason why we have one for Shawnee Heights is because even though there's a statute, the school districts, the State Board of Education, do they or do they not provide a specific form? Is this a generic form that just has the letterhead of Shawnee Heights on it, or does Shawnee Heights or any other school district craft their form to fit them?
So as I said in the memo, I'm not aware of any state agency that has a standard use form for religious exemptions. We included Shawnee Heights just as way of example. Like I said, we also included Kansas City, Kansas school district right behind it. These are just examples. The health form from KDHE is a standard use form for all school districts that has been developed by KDHE, but for religious exemption, that would be up to the local school district to develop their own form.
Thank you.
Representative Miller.
Thank you, Madam Chair. I just wanted to be clear. I think there's been some comments made that add to confusion. There is no COVID-19 vaccination mandate applicable to K through 12 in Kansas. And correct me if I'm wrong, the State Board of Education has no authority to impose one In fact, we have 11 vaccines that are required unless you get an exemption. Those are all per statutes that evolve first from KDHE adopting a regulation, then the Kansas legislature signing off on that regulation. But unlike the mandates we've been discussing these last several days, there is no mandate for our school children, nor can there be without our specific blessing. Am I right or wrong?
Scott?
So there's no statutory requirement for a COVID-19 vaccine. The statute that I referenced, the KSA 726262, the general authority for and requirement for vaccination for schools delegates setting those conditions and those vaccinations to the Secretary of Health and Environment in rules and regulations.
And they cannot impose any rule or regulation unless we then sign off on it. Are they not required to submit those?
So those regulations would be submitted to and reviewed by the Joint Committee on Administrative Rules and Regulations. There is no requirement for legislative approval. The legislature can, of course, always enact legislation that either limits or takes away that authority, but
So put a better way, we have the ability to veto by legislative action.
you could alter their statutory authority in a way that takes away the authority to adopt certain rules and regulations.
Thank you. And I just wanted to clear up because it was kind of the insinuation that there's some mandate out there subject to certain exemption. There is no such thing as it relates to COVID-19, at least currently. But thank you.
Representative Landwehr, then Representative Barker.
Thank you. I think to kind of simplify what people get a little bit confused on, I'm not saying that you are Representative Miller, you've got a lot of experience in this area, is the Rules and Regs Committee does not get to say no to a rules and regs that's been presented to them. The only way to reverse a rule and reg by the time it gets to that committee is through a bill, legislative action through a bill. The Secretary of KDHE, and correct me anytime, Scott, that I'm wrong on this, has the authority at any time to mandate a new vaccine, whether it's on adults or on children, correct? Or is it just children?
So in the context we're discussing and the statute specifically referenced, it would only be for children who are enrolling in school.
Okay, thank you. Does that help? Thank you.
Representative Barker.
Representative Landwehr asked the question. I wanted the clarification because rules and regs cannot overrule. It goes through a process, but absent legislation, it becomes effective. So thank you, Representative Landwehr.
Senator Warren.
Thank you, Madam Chair. Scott, just to clarify, Madam Chair, your last answer, you had said just for children enrolling in school. Do you mean first-time enrollment into school, or do you also mean students that are currently enrolled in school? I'm just, the word you used, you said enrolling. Do you mean the first time you're enrolling your child, or do you mean something else?
So Tamara can correct me if I'm wrong, but the statute speaks to when a child is enrolled in school.
So that could apply to current students, or is it just, I'm just trying to be clear. And if you can refer me to the statute, I'd be happy to take a look too.
Yes, Tamara.
Thank you, Madam Chair. KSA 726262 reads, in each school year, every pupil enrolling or enrolled in any school for the first time in this state.
So repeat that first part again.
Every pupil enrolling or enrolled in any school for the first time in this state.
So if you're a sixth grader and you've been enrolled since kindergarten, it wouldn't apply to you. Thank you. Thank you. Thank you, Madam Chair.
Representative Owens, then Representative Carmichael.
Thank you, Madam Chair. To bring this full circle, since I was the one that started and asked the question as it relates to religious exemptions, therein lies my concern, is that the Secretary of KDHE could mandate it and we would not be in a position, or we may not be in session at that time to do something legislatively to counteract that. So my question goes back to ensuring that religious and medical exemptions do apply without someone making an ultimate decision that they don't apply, similar to what we're contemplating with our employers. So that's what I want to make sure is that because we have ascertained that the KDHE secretary does have the authority to do so, I want to ensure that our children who may or may not be, because currently they're not, but if they were, have the ability to apply the same rules that are generally accepted for a religious and medical exemption. Thank you.
Representative Carmichael.
Thank you, Madam Chair. I hope that folks can hear me this morning. Quite frankly, didn't want to spend the state's money on mileage there and back today, so I appreciate you allowing me to watch this hearing by WebEx. My question for Mr. Abbott is, having served now on the JCAR, the Joint Committee on Administrative Rules and Regulations, for, I don't know, about 5 years or so, Senator Warren is our vice chair this year, as I recall. My understanding is that the Secretary of KDHE, as well as any other state agency head, cannot alone just adopt a regulation. In fact, every regulation that is adopted, changed, or modified has to be approved by the Attorney General prior to it even being brought to the JCAR. Is that correct?
So yes, there are statutory requirements for adopting rules and regulations that include review by the Department of Administration, the Attorney General, for some by the Director of the Budget before it can go into effect, yes.
And so what that means is that if Lee Norman, for example, wanted to mandate COVID vaccinations in Kansas, Derek Schmidt would have to sign off and approve it. Is that correct?
That would be part of the process, yes.
Thank you very much, Madam Chair.
Representative Miller, then Senator Warren.
Thank you, Madam Chair. And I just wanted to follow up on Representative Owen's previous comment. As it relates to religious and medical exemptions for vaccination mandates emanating from KDHE, it's part of the statutory framework that any vaccination that they order carries with it, under the statutory framework, room for medical and religious exemptions. These 11 that we now have all have such exemptions, and it's not because they were singularly adopted. It's any mandate carries with it those exemptions. Am I not correct?
Yes, so this is the framework laid out in KSA 72, 62, 62 for all of those vaccinations that are required.
So if KDHE imposed a requirement for COVID-19 vaccines and the Attorney General approved it, there would be no need for us to revisit the exemption requirements because it would have to carry the same ones that the ones we currently have currently do.
If a new requirement was adopted under that same procedure, it would have those same exemptions.
Thank you. Thank you, Madam Chair.
Senator Warren.
Thank you, Madam Chair. Thank you, Scott, again, for answering the questions today. Regarding Joint Committee on Administrative Rules and Regs have to go through several different approval processes before they come to the Joint Committee, including the Secretary of State and things like that. And just for those listening and following online, could you clarify that if along the way some department or agency doesn't approve of the rule and reg, is it always the case that it is then not presented to the Legislative Committee on Rules and Regs, or does it nonetheless get presented to the Administrative Rules and Regs Committee, but without the stamp of approval of the agencies that are looking at it?
I'm hesitant to answer that because it's getting a little bit out of my wheelhouse. My understanding is that for a rule or regulation to go into effect, it has to go through that entire approval process of the required officials.
That it goes through the process, but it's not always approved by each step of the way, but nonetheless presented to the committee. And if it's not an area that you're familiar with, don't guess, I guess is my point.
Sure, no, I wouldn't. I'm just not aware specifically of the circumstances under which the Joint Committee receives rules and regulations, so I would not be prepared to answer that.
You wouldn't be able to answer. Okay, thank you. Thank you, Madam Chair.
Representative Carmichael.
Thank you, Madam Chair. I don't want to substitute for the reviser here. I do know the answer very clearly to Senator Warren's question, but rather than hearing it from me, could we ask that the reviser's office check with one of the revisers who handle the Joint Committee, because I'm sure they will find out that unless the Secretary of State, the Department of Administration, the Division of the Budget, and the Attorney General have all four approved the regulation, it doesn't even get to the JCAR, and it never is adopted if the Attorney General vetoes it. So could we ask research to do some quick, or the reviser or one or the other, do some quick research and maybe give us a report later this afternoon?
We'd be happy to.
So requested. Thank you, Representative. Any other questions for the reviser? Seeing none, thank you very much, Scott. Next, we'll have an informational hearing on Bill Draft RS 2356. This is requiring exemptions from employer COVID-19 vaccine requirements and providing for waiver requests and a civil action for violations related to exemptions. Conferees, you will have 4 minutes each, so I ask that you keep your remarks to that time limit. You will be given a little warning at 1 minute and 30 seconds and then when to stop. So would appreciate that. Before we get started with conferees, Jason, would you review that draft for us? Thank you.
All right, good morning. Thank you, Madam Chair. Good morning, committee. We just did this the other day, but I'll give you a very quick overview of RS 2356. You now have a more formal overview of that on our letterhead. Essentially, this is the draft that would require exemptions from employer COVID-19 vaccine requirements and provide for waiver requests and a civil action for violations related to those exemptions. There's a proposed new section of law here. If an employer implements a COVID-19 vaccine requirement, which is a defined term, as we'll talk about in a second, the employer will be required to exempt an employee from that requirement if the employee submits a written waiver request that meets one of 2 statutory options. Just to walk through those 2 options real quick. First, the employee may state that complying with the requirement would endanger the life or health of the employee or an individual who resides with them, and that is evidenced by accompanying written statement signed by a physician licensed by the State Board of Healing Arts or an advanced practice registered nurse that's licensed by the Board of Nursing. The second option is if an employee states that complying with such requirement would violate their sincerely held religious beliefs, and they evidence that by an accompanying written statement signed by the employee. There is a caveat that the employer shall grant an exemption requested on this basis if on this basis of sincerely held religious beliefs without inquiring into the sincerity of the request. The draft then defines that term we talked about earlier, COVID-19 vaccine requirement, to mean an employer requires an employee to receive a COVID-19 vaccine or requires an employee to provide documentation certifying receipt of a vaccine, or they enforce a requirement that I just described that is imposed by the federal government or any other entity. So any of those would meet the definition of vaccine requirement. And also recall that the definition of vaccine is deliberately a little broader than you might expect in this draft to cover the various issues that we've talked about in the committee about whether this qualifies as a vaccine under the traditional definition or not. So I thought I'd clarify that because we did discuss it, and I wanted anybody listening today to hear that as well. Finally, I'll say that the draft provides that an employee aggrieved by a violation of this section can bring a civil action in a district court in our state against the employer for injunctive relief, actual damages, et cetera, and they are also allowed, if they prevail, they shall be granted the cost of the suit and reasonable attorney fees. And with that, I'll stand for questions.
Representative Owens?
Thank you, Madam Chair. I know this wasn't specifically touched on, but just for clarity and putting it out there, is there anything in this bill draft that prevents an employer from accepting that religious exemption and then placing that employee on 90 days unpaid leave?
Madam Chair, Representative, there's nothing in the bill that discusses what an employer does next. So if that would be allowed under our labor and employment laws, which I'm not an expert on, then there's nothing preventing that in this bill.
Thank you, Madam Chair.
Senator Thompson and Senator Petty.
Thank you, Madam Chair. Just wanted to clarify again, Mr. Thompson, that the definition of employer is wide enough to cover anybody who is a contractor or vendor to a company who may require them to have a vaccine to be able to do business with that company.
Madam Chair, Senator, you raise an interesting question. The definition of employer in the bill is pretty straightforward. Any person in this state who employs one or more persons and includes the state of Kansas and all political subdivisions of the state. So that's an employer. Anybody who's employing someone, including the state. The potential way that a subcontractor or a vendor, so I guess there's a two-part test here. First, does imposing a requirement on your subcontractors or your vendors, does that count as a COVID-19 vaccine requirement under the definition? Likely yes, right? Because you're imposing that they show you proof of vaccination, right? So that's probably how it meets that. So that's step one. Step two then would be, are they an employer of that person? Is that person their employee? The answer is clearly no. That's not their employee. That's the employee of someone else. But that person is an employee of somebody who probably is an employer. So that employer is enforcing the mandate from the person above them, the other employer, right? So they might fall under the definition of a vaccine requirement because they're enforcing someone else's vaccine requirement. Does that make sense? So it's kind of a difficult way to get there. But I think it works. So I think if a business does impose that requirement, it is a vaccine requirement. And I think if the employer of the subcontractor, so the subcontractor or the vendor, if they impose that requirement passed down to them on their employees, then they're an employer under this bill that has to allow an exemption, right? So it just sort of goes down the chain, if that helps. It's a little more difficult than I'd like it to be, but it seems like it's covered. And you didn't ask this, but there is maybe an issue with independent contractors and whether those are employees, which is a related issue. So I didn't want to leave that out. It's something we're aware of and maybe a topic of discussion here.
Okay. Thank you. That clears it up. Thank you. Sort of. Thank you, Madam Chair.
Senator Petty, then Senator Warren.
Thank you, Madam Chair. Jason, so in the draft that we have before us, an employee that doesn't want to comply with the vaccine requirement, they have to go through the process of filling out a form. They can't just walk out the door and then go to and then file a lawsuit. Is this or is this not correct?
Madam Chair and Senator, essentially correct. I'll just rephrase so it's my words and I'm not just saying yes. For an employee to ask for an exemption, the statute would require a written waiver request to the employer. And that has to have either a statement from a medical person that's allowed under the statute, if it's medical, or a statement from the person themselves, if it's a religious request. After that exemption is essentially an employer could not violate the statute and aggrieve a person, an employee, unless those requirements are met. So you have to be an employee who's aggrieved by your employer's action, And you can only be aggrieved if you follow the statute and file your written request. So you're going to have to do that step to be an aggrieved employee to be able to file a lawsuit. Does that help?
Yes,
Okay.
it does.
My words are a little more complicated. I'm sorry. I'm a lawyer.
Thank you, but I appreciate going through that process. Then my second question is there a definition for the word sincerity?
Madam Chair and Senator, so we use the term sincerely held religious beliefs because that is a pretty well-established common law term. So I think there's a lot of case law and other things out there that may apply to that term. So that it was carefully chosen for that reason, but it's not defined here in the bill.
All right, thank you.
Senator Warren, then Representative Tarwater.
Thank you, Madam Chair. Thank you, Jason. We're talking about definitions in the bill. Employee, we don't have included in there, do we? Independent contractor?
Madam Chair and Senator, I don't think it's clear. I guess that's the best answer I can give. Generally speaking, in our labor and employment laws, I was doing a little more digging on this after the fact, employees probably don't include independent contractors unless we say they do. So that's not necessarily an oversight, just maybe something we didn't talk about in the drafting process. And if the committee wanted to add that, we could certainly change the definition.
Right. And it is clear in law that employee and independent contractor are different, but sometimes it's not always so clear. So we should be clear with what we intend.
Senator, yes. Generally, it seems like if it's not clear that an independent contractor is an employee, there's usually enough difference between the two that they're not considered the same thing. And there are various reasons you might call someone an independent contractor and not an employee, tax purposes, withholdings, insurance benefits, numerous reasons. So I think with all of that foundation, if we don't say that they're included, they're probably not. And so if you want them included, the safest thing to do would be to specifically call them an employee, just so that there's no question.
Exactly. Thank you, Madam Chair.
Representative Tarwater, then Representative Landwehr.
Thank you, Madam Chair. I have two different questions, if I may. The first one is regarding medical exemptions. There's a concern that I've heard of some people not wanting to release what their medical condition is. It could be an embarrassing issue, or it could be an expensive one for medical insurance. And they don't want to necessarily alert the company to this medical issue and be terminated for that or discriminated against for that. And so the way I read this bill, as long as they say that there is a medical issue and a doctor says, yes, there's a medical issue and we advised against taking the vaccine, is that all that's required under this bill, or does this bill allow for an employee to do, or for an employer to drill down further on what the medical exemption is?
Madam Chair, Representative, so the statute, the language in the bill draft is pretty specific, that it just has to be a statement signed by one of the medical professionals that complying with the requirement would endanger the life or health of the employee or an individual who resides with the employee. So that's all that's required under the statute. Now, as you just heard from Scott Abbott in our office, it's not necessarily the case that they'll have a form that might ask more than that, and whether the employee complies with that form or submits their own written statement that only does what the statute requires, that's maybe left a little bit open. But I would also give the caveat that all of that is protected medical information, and there are anti-discrimination laws and the ADA and other things that would apply, so that maybe the consequences of revealing that should be pretty well protected. If an employer were to do something because they found out about one of your conditions, I think you're falling under some of the current law, and you might have a federal lawsuit on your hands. So just to give that background as well.
Okay, thank you. And then if someone has a closely held religious belief and they are able to stay at their job, there's nothing in this bill that inhibits an employer. They'll still have the ability to enforce other traditional performance management issues as it relates to the employment, correct? They don't get carte blanche immunity from being fired. The employer can still manage that employee, is that correct?
Madam Chair and Representative, yes, there's nothing in here that deals with any other aspect of your employment except for the vaccine requirement itself. We're still in employment at will state, so all of that is in play.
Thank you.
Representative Landwehr, then Representative Barker.
Thank you, Madam Chair. And I think we need to clarify this because we have a lot of subcontractors in this state that travel this state and are going in different types of businesses. And currently, they are required to follow whatever the protocol is of the business that they're going to be going into. And if their protocol requires a certain vaccine, et cetera, then they have to comply with that currently. So I don't think that anything that we do here is going to change that, because if that employer requires that, then the sub would have to comply or not go into that facility. Would that be correct?
Madam Chair and Madam Vice Chair, let me take one more shot at that question since it came back up again. I didn't explain it very well the first time, so let's try again. If an employer imposes a vaccine requirement that meets the definition, which it sounds like it would, right, either directly requiring a vaccine or requiring proof of a vaccine, if they impose that on their subcontractor and the subcontractor passes it along to their employees, that subcontractor is now an employer under this definition that is enforcing a COVID-19 requirement because it is under C. It is imposing the requirement from another entity. Right? So it's imposing a requirement that was handed down to it from the entity that it's working with. So I think they're probably covered. To be maybe a little more frank than I'm usually with the committee, the draft is contemplated to only deal with the employer-employee relationship. This is an issue that probably is dealt with, but if you really want to deal with it, it might require a little bit different structure and drafting because it just wasn't at issue in the draft as it was done. I think we end up with the same result, but maybe it's not as clear or as clean as you would like or as others would like. And to make it clean might require a lot more changes than you might suspect, just because of the way it's drafted currently. It's not really contemplating that relationship directly. It's more contemplating an employer passing it on to their employees or another entity passing it on to various people. And so, yeah, I'll stop there.
Well, I think that's probably going to be the piece, Madam Chair, that's going to be difficult for some folks to understand that maybe work in a subcontract relationship with a lot of different entities around the state. So at some point, not today, but as we move forward, we need to make sure that we are able to clarify that in a simple form for individuals to understand. Thank you very much.
Representative Barker, then Senator Warren.
Thank you, Madam Chair. I'm going to go back to the form from Shawnee Heights Unified School District. I was just looking at it, and it's got a signature for a parent, only one parent. And I would like research to be able to look and say, okay, would that be, in a case where divorce, would that be the parent with custody or the parent with non-custody could also sign for this? Or in cases that there is joint custody, does both parents need to then sign to get that exemption? And there's probably some case law out there in domestic relations courts that may help clarify that, who can sign medical consents, whether it's the parent with primary custody or parents with joint custody or either parent. I could just see problems in the future, one parent signing and the other parent objecting. And I'm sure it's probably been litigated before, but I'm not familiar with that case. So if we could have a research look at that, I would appreciate it. Unless they have that answer now.
Dylan, is there an answer or can you get that for us? I saw some discussion going on. Tamara?
Thank you, Madam Chair. The language in the statute reads a written statement signed by one parent or guardian. This particular act does not define parent or guardian, so we're going to look and see if there's some case law that might give us a little bit more clarity.
Does that satisfy your
It does.
request, Representative?
Yeah, thank you. But could you send me a document that would refer to that? I said, could you send me a document where you're getting that from? Thank you.
Tamara, if you would send that to all committee members. Thank you. Representative Landwehr, did you want to respond to that?
Well, and I think in response to where Representative Barker was going with that, I think currently with our schools don't necessarily ask for documentation. Is there joint custody? Is it single custody, et cetera? So I think a lot of that happens today where one parent signs off on something. So, I mean, it's a good question and it's something we should look at, but just FYI, that currently happens in our schools today.
That may be, but I used to do these type of cases, and when you've got divided custody, or especially joint custody, and one may have some strongly held religious beliefs and the other doesn't, and that's the reason they're divorced, they're going to end up in domestic relations court again, or they're going to be challenging the statute, and that's the reason I wanted some case law on it. But thank you for that.
Okay, Senator Warren, then we're going to move on to our conferees.
Thank you, Madam Chair. Jason, a couple of questions, if I may, Madam Chair, and keep them brief, because I understand we need to move on. This bill is in response to the Biden administration executive order, the OSHA Act requirements, and regarding CMS facilities as well. So in responding to those from the Biden administration, do any of those specifically require anything of independent contractors? Or I guess my question is, those only address employer-employee relationship. Am I correct on that? I don't have those in front of me, and I know we've talked about those a lot, but I'm trying to keep it a simple yes or no question.
Madam Chair and Senator, I'm not sure it is a simple yes or no question. I wish it was.
I tried.
Because each one is slightly different, right? So if you start with the executive order, you've got one that's for federal employees.
Employees, right? Not independent contractors.
Right, and as I recall, it defines employees using a federal definition that I'd have to go dig back into, and I don't know if it includes federal contractors or not, but that's really not one at issue here anyway, right? I mean, we're not talking about federal employees really in our bill, right? They're not state, they're not employed in the state by one of the entities we're concerned with, really. So that one's kind of set that one aside. The other executive order dealt with the contractors and the subcontractors, and I think it said, basically at any level. So pretty much anybody that has a contract or agreement with the government to do things are covered by that one, as I recall. So I mean, it poses it more at the entity level, and they would have to pass it on. So if they do pass it on to an independent contractor, this, might be in play and it might not. The CMS rule, I'm looking to Scott to make sure I don't step in something here, but I mean, it's talking about providers and other folks who are working in the facility. That might include an independent contractor who's a provider and working there just by the nature of that definition, and they're passing it on to them. And then the OSHA one, that one's a little more direct because under OSHA, you only have obligations to certain employees and not to, that's more like workplace safety, and there are very specific rules about that. So there's a little nuance to it. And remember that this section is not just in responding to those, it also would respond to any private employer who imposes their own COVID requirement, right? So not just one imposed by the government, but also maybe their own.
Thank you. And nothing in the bill requires an employer to make any particular form to be used as the written statement by the employee, right? The employee could make their own written statement on a piece of paper, and there's no burden on the employer to come up with a form, as the bill is in front of us today, right?
Madam Chair and Senator, it just requires a written waiver request. It doesn't specify anything has to be created. It appears to me that you just submit your waiver and your written statement, either written by you or written by a medical person, and that's it. So I don't think there's anything required of anyone other than write it down.
And one last question, if I may. an employer under this bill could still require weekly testing of an employee, weekly testing for COVID-19?
Madam Chair and Senator, it's pretty clear that the requirement that's imposed is either requiring them to receive a vaccine or requiring them to provide documentation of vaccination. Once you get an exemption from those requirements, the statute's silent on what happens next, right? They could impose other requirements that may be required by an OSHA rule, for example, related to masking or distancing or things like that. So it doesn't get into those. It only gets into the initial requirement and waiver of that initial requirement.
And it doesn't get into who would be paying for the COVID-19 testing if that's something that the employer does. And
correct.
It doesn't. Okay, thank you. Thank you, Madam Chair.
Thank you, Jason. We're now going to move on to Proponent Testimony Committee. If you will hold your questions until the end of the proponents, and then we'll ask questions after they have all testified. First, we have Lauren Schiffman. Lauren, welcome to the committee.
Thank you. Real quick, Madam Chair, before I start my testimony, may I please answer Senator Warren's question? Because I actually am a vendor at a hospital.
You may, it will count toward your 4 minutes.
Okay. We are required, by the way, to comply to the hospital's requirement. So thank you, Madam Chair and committee members. I am a proponent of this effort, but this bill does not go far enough to protect Kansans. This bill does not protect against discrimination, and it doesn't hold the businesses accountable. As you all heard last month, I actually got denied my religious exemption, and my last day of my job is December the 6th. But even if this bill would have been in effect and I would have been able to retain my job, that would have subject me to very significant discrimination at my work, and my work would not be sustainable. To give you a few examples, I would only be allowed to go to one building. I could never go off-site to visit any other meeting, customer, nothing. I can never, ever remove my mask. I'm serious on this. I'm not allowed to take a drink of water in any proximity of anybody in a public location. I'm not allowed to go to the cafeteria. I'm not allowed to eat anywhere in public. Essentially, I have to go to my car. So with these restrictions, it's like I'm in prison and I'm punished every single day just for asking for the accommodation. I'll tell you, this is by design. It's to get people to either submit to the vaccine or to coerce them or leave. For example, my colleague that got her medical exemption approved only because she got asked for 8 months, she is not allowed to visit any of her customers anymore. And that is actually creating a situation from which my employer can fire her for cause because now she can't do one of her essential job functions. So where are the damages? Where are the penalties? How are we going to get compliance from these employers? I think the answer is in SB 212 and SB 213 that was presented to this body earlier this year. Because in Section B of SB 213, it actually allows for damages. So in this final bill, we have got to address this discrimination problem, because without it, this bill does nothing but reaffirm the laws that we already have on the books that the employers aren't following. We've got to change the accommodation requirements so that they're very similar to ADA of a minimal burden. We have to allow for immediate litigation. So I filed an EEOC claim. My hearing is not till May the 3rd. I can't even sue till May the 3rd, and I have no job as of December 6th. That doesn't seem right. And we have got to allow punitive damages, or these employers will just continue to discriminate. And lastly, I want to just share with this body an experience I just had with my children last night in regards to the shots for the kids. It's very appalling. So in the last week, I've gotten 4 text messages and 4 calls from my pediatrician to bring my child in to get the COVID vaccination. I had my child's well visit last night, and I went in there and I asked if I could have a package insert so that I could potentially get informed consent. They didn't have one. Let that sink in. There was no package insert in the entire pediatrician office. And They are saying that they're giving informed consent, but I don't know how you can do that if you don't know. So we need to stop all of this coercion that's going on, especially with the kids and the employees. Thank you very much.
Thank you for your testimony. Next, we have Debbie Jatmer. Welcome to the committee, Debbie.
Good morning, and thank you for hearing all of us, Chairman and committee board members. I am Debbie Jatmer from Shawnee, Kansas. I'm a grandmother of 8 and a retired registered nurse. I want to thank you for standing against the tyranny we are under and the overreach of the government and the schools and our employers. I am so happy that you address and realize that each person's religious belief is personal and no other can judge that person's beliefs, and nor should they be brought into questioning for these beliefs. I agree with that portion of 22 SR 2356. But having to get permission from a physician with a note, this is just one step from vaccine passports. And also, your physicians are not writing these exemptions for the mask or the vaccines due to their personal attacks on their lives and their licenses. And with any recommendation from my physician, the choice still lies with me, the individual with personal autonomy. So my priority is our constitutional laws and our rights and the violation of them right now from the federal government, schools, and employers. We have rights and laws protecting us right now. Please stand on those laws and our personal rights under the Constitution. The federal government has made unlawful mandates and took unlawful measures to push those unlawful mandates to the OSHA, CMS, employers, employees, schools, businesses, and our children. And one note on when I went to the doctor, just so we can get that off my chest, when I asked for a mask exemption from my KU doctor because I struggle to breathe due to my emphysema, I was told, no, we don't give them out. And they don't give out the vaccine exemptions either. So the federal government has made unlawful mandates. Oh, I did 7. So in conclusion, these federal acts are unconstitutional. We need you to protect each individual and their personal autonomy, their religious beliefs, and personal choices of their health. Simply, no private or public employer or school can compel its employee or student or any person to undergo any COVID vaccine testing, masking, or vaccinations, or use the wording that we have in SB 212 and SB 213 bills already. Bring them forward again. I support following our Attorney General's belief that any and all these federal government mandates are unconstitutional, so therefore null and void. I'm requesting you all to support that belief also. Stop all COVID vaccine testing, masking, and vaccination mandates, period. Stand united in Kansas with our Attorney General. Thank you.
Thank you very much. Next, we have Laura Klingensmith, followed by Gary Morgan. Laura, welcome to the committee.
Good morning. Biden wants to use OSHA as a way to create a national pre-employment condition on the American workforce. CMS wants to turn last year's unvaccinated heroes into this year's unemployed recipients. All of what is happening to our freedoms are unconstitutional, and you know this because our Attorney General has filed 3 lawsuits on our behalf. He is doing what needs to be done to try to protect our health freedom. So now you will have a special session next week. Will you also fight for our health freedom? Or will you choose the agenda of lobbyists, special interests, and the Kansas Chamber over us? If you choose us, you have work to do, as the bill you have proposed is worthless. Our freedoms are in jeopardy, and it's up to you to save them. Bill 2356 does not have the language to protect our health freedom, nor does it have language to protect the unvaccinated from segregation and discrimination in the workplace. Kansans should be able to work without sacrificing their health freedom. You drafted a bill that only allows doctor's notes and religious beliefs as exemptions. So a doctor has to worry about an investigation from the state board when complaints are received with the sole intent to silence the doctor by going after their medical license. Their job will be on the line for signing exemptions. That is passing the buck, when in fact you should be passing legislation to protect our freedoms. I am 50 years old, and I do not need a doctor's note to make my own health decisions. The other option is religious exemption. Do I need to start singing hymnals in the workplace to prove my religious beliefs? Do you even realize how horrifying this bill is because it does not give me personal autonomy and choice? I am the only person who can decide if I wear a mask or my child wears a mask or if we take a COVID test, a COVID vaccine, and who we share those decisions with. COVID vaccine mandates are unconstitutional. And if you pass this bill as written, you are stating otherwise with complete disregard to our health freedom. You do not need to recreate the language. You simply need to look to Florida and Montana. They are putting their voters first. They are stopping the overreach of government, school districts, universities, and private businesses. So I encourage you to pass legislation that protects our health freedom from any and all mandates related to COVID, regardless of who issues them. Pass legislation that keeps medical decisions private. Pass legislation that keeps our jobs and our freedoms from being stolen by Biden. I challenge you to put Kansans first. Thank you.
Thank you. Next, we have Gary Morgan, followed by Greg Short. Welcome to the committee, Gary.
Thank you, Madam Chair, Representatives, Senators, and we the people. I stand before you again today to voice my general support for any anti-mandate legislation against Biden's cruel executive orders. The draft bills we are asked to comment on today, while a step in the right direction, they don't go far enough to end the madness that's being and about to be inflicted on the masses of Kansans we are here, supposedly, to defend and protect today. Now is not the time for playing partisan politics. Even Governor Kelly is waking up and smelling the coffee that we, the people of the state, are very angry, and maybe, just maybe, she's finally seeing the light. If she stands behind her social media post from last week, she should be willing to sign legislation that essentially neuters Biden's unconstitutional forced mandates. This is simply a question of right versus wrong, good versus evil. Either you stand against Biden or you stand with him. Your choice, but you'll be judged accordingly. I'm not going to speak to what Laura and Lauren have already spoke to, but we need to put teeth in the religious exemption for employers. And I'm going to go to another consideration, which is the first point of this bill, called for the medical exemptions, because you really have to consider another reality today that's going on. I was diagnosed with AFib this summer. So far, it's a mild condition, but serious enough I had an insertable cardiac monitor put in my chest in August, continually to communicate my heart rhythm information back to a monitoring lab in the event I'm experiencing AFib without knowing it. Maybe I'll get a call shortly. Since my employer is likely going to impose a vax mandate, I thought I could simply get my cardiologist to approve a medical exemption for me, given both the VAERS data to date and real-life experiences being shared everywhere except on the owned mainstream media, showing these DNA-altering shots horrible impacts on healthy hearts. I'm not a young man. I'm a runner, an avid cyclist, and in my pre-COVID days ran half marathons, triathlons, century bike rides, often under cardiac stress for 5 and 6 hours at a time. Videos from all over the world are showing famed high-performance athletes dropping dead of cardiac arrest on playing fields, experiencing career-ending side effects. Wisconsin Senator Ron Johnson hosted another vax injury and death hearing a few days ago that all of you should take the time to watch. It's utterly shameful what these untested and non-effective jabs are doing. Back to my doctor. Well, much to my surprise, Stephanie, the nurse to my cardiologist, Dr. Lackaretti of HCA Midwest Health Kansas City Heart Rhythm Institute in Overland Park, called me to say, not only doesn't Dr. Lackaretti write or approve medical exemptions to anyone seeking the COVID jabs, he highly recommends to all his cardiac patients, regardless of their condition, to take both jabs and to stay current on them. So just like that, I was put out on the street with no medical recourse, without even an invitation to discuss my personal case with Dr. Laccarati. You may remember I had COVID a month ago, too. We need protections from these corrupt medical establishments that are not only playing into Biden's mandates, but through big pharma control and payouts are helping to implement such mandates, evidenced by Pfizer's new TV campaign showing children having got the jab as being superheroes. A gene therapy manufacturing having zero legal liability whatsoever, enticing children to take jabs to become superheroes? That's as criminal as Camel cigarettes being advertised to young people in the 60s and 70s when big tobacco knew that nicotine was addictive and tar-filled smoke was carcinogenic. Simply put, we need laws now for self-declared medical exemption that don't require the signatures of specific doctors, but only include the name of the doctor whom issued the medical diagnosis being claimed for the medical exemption. Dare the employers to reject them with damaging fines. One last statement. A vast number of growing of us feel this is really a war against worldwide eugenics.
Thank you, Mr. Morgan.
And in my
Appreciate
closing
your
statement,
testimony. Thank you, and let me just remind conferees, when you go long, it's going to cut the remaining conferees' time short, so please stick to the time frame. Next, we have Greg Short, followed by Sean Hield. Welcome to the committee, Greg.
Good morning, Madam Chair and committee members. I work for Kiewit Corp in Lenexa, Kansas, and I represent a group of about 115 employees there, and mostly unvaccinated. And they're all in agreement these mandates they just can't stand. They can't be allowed to stand. And we've reviewed the legislation. I passed that on to them. I was in the committee meeting on Tuesday, and we think that it has good intent, and we think it looks like it should pass some legal challenges. But we also think that it doesn't go far enough regarding protecting the rights of the citizen when it comes to medical exemption. It's addressed in the bill, but it doesn't go far enough to define what the employers can and cannot do regarding accepting or denying a medical exemption. Similar to how the federal government tread on our rights for religious freedom when they issued a list of questions to our employers to test our sincerity, they did the same thing with the list of questions from the CDC about what is and is not an acceptable medical reason for getting a vaccination. That's ridiculous. Who's more in the place to make a decision about whether the medical reason for not getting a vaccine? My company full of engineers or their doctor? Furthermore, the doctors are being bullied by various medical boards and group practices not provide written exemptions unless they line up with a minimal number of exemptions the CDC has pre-approved. I would direct you to the October 30th in-person testimony of Randall Anstadt. If you want to review his testimony, it can be found at 1 hour, 2 minutes, and 26 seconds of the October 30th video. Mr. Anstadt in late 2020 had open heart surgery. He's pro-vaccine, and he testified that his doctors, including his cardiologist, recommended that he not get the vaccine. Fast forward 60 days. Mr. Anstadt is a defense contractor. Mr. Anstadt needs a medical exemption. Mr. Anstadt's doctors are now telling him they cannot provide him a medical exemption. One even stated that his medical group doesn't allow them to provide exemptions. I have a coworker in my group with a similar situation. She has an autoimmune disorder known as lupus. Her doctor in early 21 recommended that she not get the vaccine since they didn't know how her body was going to tolerate that. Fast forward in the last 60 days, her doctor will no longer refuses to give her a letter for fear of repercussions from the licensing board. Turns out she has a colleague that's provided an exemption for another patient with similar issues, and that she's now being audited because autoimmune disorders are not on the list of CDC pre-approved reasons for not getting the vaccine. Another person I direct you to a written testimony for this committee hearing from Michelle Courtois. She's also a coworker in my group. She also has an autoimmune disorder. Now, she tried working that through licensed physicians. Over the years, she struggled with this for a long time. And she ended up having to go the homeopathic route. And her homeopath agrees with her that she should not get this vaccine. But she has no idea if our employer is going to accept that or not. In summary, I recommend that you pass 22 RS 2356, but not before it's amended to remove the ability of the employer to disapprove a medical exemption request, which is documented by a licensed physician or other certified caregiver. Moreover, I recommend that you draft additional legislation protecting those doctors and caregivers from reprisal by medical boards and medical groups for simply keeping their patients' best interest in mind. Thank you for your time.
Thank you very much. Next, we have Sean Hill from Libertarian Party, followed by Deborah Mize. Welcome to the committee, Sean.
Thank you again for calling this committee and considering our testimonies. It's important to remember that your job is to be accountable to and to represent us. We appreciate those of you who sit on this committee, despite its apparent unpopularity among many of your colleagues. I remind those not present that they are elected officials. I favor nullification here, but time is short. We need a multi-pronged strategy with immediate action. The lawsuits take too long, and we can't rely on federal courts to stop this. Compromising my libertarian principles, I ask the state to impose liability on the companies that require vaccination causing injury and death. If these shots are as safe as claimed, these employers should have no problem covering the costs of the rare side effects. This is a real concern with Big Pharma exempt from liability under the PrEP Act. Today's draft bills are a step in the right direction, but we need something that addresses workplace discrimination rather than just protecting unemployment after we're fired. Discrimination will be rampant between charging us to test and the masks serving to divide and dehumanize, not protect. The CDC's own study shows the ineffectiveness of masking by the public. We need sections for conscientious objection and to ban the vaccine passport in all forms. Legislation protecting jobs, unemployment, and liability should be retroactive to the first mandates from the employers. I urge you to model something with teeth like the proposed Senate Bills 212 and 213. Normally, I could not endorse such interference in private business affairs, but these are not normal times. The President has drafted OSHA and employers as middlemen to coerce us into unwanted medical treatments, knowing that it won't hold up in court. He threatens the careers, health, and souls of tens of millions of innocent Americans. Imagine such power over your body being wielded by the worst political boogeyman that you can conjure up, recalling how unpredictable our elections have been lately. It isn't hard to envision some dark futures in this new normal. Here, we must back the rights of the individual. When these private businesses carry out government's every whim in exchange for benefits and public funding, how private are they really? Many of these companies eagerly jumped out ahead of the OSHA rule and began coercing their workers based solely on the executive orders. Some of them are already having adverse events. This public-private partnership cannot be overlooked. This brings us to liability. At Tuesday's meeting, the difference between Comirnaty and Pfizer was in question. This is a nebulous topic, but Comirnaty is the only approved one covered under the Vaccine Injury Compensation Program, VICP, funded by a tax on vaccines. It doesn't seem to be available and is legally distinct from the emergency use authorized vaccines. My wife, Michelle Mayo, covers this in depth in her written testimony. The EUA vaccines fall under the CICP, the Countermeasures Injury Compensation Program, which only rarely approves settlements. When and where can we get actual Comirnaty so that we can be sure that our injury settlements are covered under VICP? Someone must be liable for all of this suffering. At this point, most of us know someone who has had injuries with the vaccine. OSHA often says that they're underfunded and understaffed and cites how it would take 160 years to inspect every business. About 2,000 people work for OSHA, one inspector for every 82,000 workers. They can't enforce this without state help. Kansas does not have an OSHA state plan where we do our own enforcement like 22 states do, and that's worth pursuing, but I ask you to draft legislation to ban all material support and manpower for the enforcement of any such tyrannical federal mandates. A stronger medical analog of the Second Amendment Protection Act to protect the individual's right to bodily autonomy and ban such coercion by any party. The mandates threaten not only human rights, but the nation itself. The cancer of corporatism is eaten at the fabric of this nation and sown public distrust. The executive branch overstepped its limits long ago, but this latest action is unprecedented. The more the government tries to force such arbitrary, unscientific, and immoral dictates on us, the more its legitimacy dwindles. Americans accept a lot from our presidents, but when they come for our jobs and children, we turn serious. With Washington seeming as politically removed as London must have to the colonists, we look now to you and expect substantive action. This cannot wait. VAERS is over 18,000 deaths and 800,000 injuries. Some now want school mandates, though children are at virtually no risk of COVID. For a glimpse at the future, if we don't stop this, see the lockstep scenario in the 2010 Rockefeller Foundation document. We're looking at technocratic totalitarianism, and we must prevent this insanity. Thank you.
Thank you. Next, we have Deborah Mize from Kansans for Health Freedom, followed by Martin Tinker. Welcome to the committee, Deborah.
Thank you, Madam Chairman. I am one of 3 praying grandmas that founded Kansans for Health Freedom in 2019. I am not a public speaker. I do not get paid to be a lobbyist for KSHF. I get no reimbursements for any expenditures. Unlike some of the lobbyists in this room, I am simply a praying grandma who is trying to protect the freedom of my children, my grandchildren, and my husband and myself. And I'm also here to speak for the families who cannot be here today, for the little girl who died of an MMR vaccine. Yes, that is on her death certificate. Vaccines are not safe and effective. Do like I did and ask for the research that shows they are safe and effective. I myself understand viruses. I understand the polio vaccine. I lost a kidney to it. I speak as well for my friend whose son was born with microencephalopathy after being coerced into getting a DTaP vaccine at 5 months in her pregnancy. He will never live to go to school, to have his first date, or to get married. You cannot imagine the expenses that this family is saddled with as they care for their little boy. I speak too for the 12-year-old girl in our community that died this week after being coerced into taking a COVID injection. I speak too for the man that also died in a community just south of mine, 27 years old, was forced by his employment to take the injection. He is not here to speak for himself. His family is attending his funeral. I speak too for the aborted fetal cells that are in all 4 of these vaccines that are currently on the popular list for COVID injections. Do any of you have any idea how these aborted fetal cells are harvested? I'm going to go there right now, and I apologize for the graphics. This is very hard for me. The fetal cells are taken from aborted babies that must be born alive in the fluid sac. Those fluid sacs are then slashed, and then the baby's neck is slashed. Unlike Dr. Epley tells us, there is no cleaned up aborted fetal cell in a vaccine. Thank you very much.
Thank you. Next, we have Martin Tinker, followed by Bill Mize. Welcome to the committee, Martin.
Thank you today for the time to speak. My name is Martin Tinker. I'm from Wichita, Kansas, and I have a small but growing group of about 150 parents, students, and general employees from around Wichita. I was very nervous Before I came here, thinking I would be alone, I'm excited and pleased to see all the encouragement and similar messages that I plan to deliver from the proponents here today, and I hope to meet every one of you afterwards. No mandates ever. Please know that my family has received all of our scheduled vaccinations up until COVID. We masked without any real protest, and we acted as most of us did in the 15 months after COVID began, with compassion. What is going on now is wrong, and it is a failure of product, policy, and leadership. 6 months ago, I was worried that our children would be subject to another year of masks, mass quarantines, and loss of education. These are very real concerns for me and many others, but they have all been surpassed by forced vaccinations or lose your job. Forced vaccinations or your child can't go to school. As we have been living normally for quite some time, how can any of us reconcile how a man or woman should lose their ability to feed their family because they will not be coerced to accept this failed product, these failed policies, and our failed leadership? As we have acted with compassion over these last 18 months, we have fallen asleep in the false hope that we will all be safe if we can go back to normal if we can keep our job if we. This should have never been the case, and our leadership should have been the first to rebuke these failed policies and veiled threats, whether it be from the federal, the presidential administration, or local corporations. While our faith and freedoms have granted us a bountiful life, we somehow have convinced ourselves that unless we comply, then we have failed. It is in total compliance that we continue to fail. In this light, we urge and encourage our leadership to recognize that God, faith, and compassion for all need to lead us right now and always. Recognize that there is a negative side to every mitigation proposed and used, and our leadership better realize this before they blindly accept another one. Recognize that no mandate should ever be supported within our state or country. Recognize the real injustice being carried out by many of our corporations and government authorities every day with their continuation of vaccine mandates. I emailed a lot of representatives and senators this week before I came up here, before I submitted my written testimony. I got a lot of support from folks. I appreciate it. I got a few folks who were not in my corner. I appreciate that feedback as well. It came down to vaccine access and the public health. I'm all supportive of that. Vaccine access is great, and I hope everybody can have it that wants it. The public health is a public trust, and when you mandate these types of things, you break that trust.
Thank you. Next, we have Bill Mize, followed by Tom Salt. Welcome to the committee, Bill.
Thank you. Good morning, Madam Chair and members of the committee. When we were here in October, we told you about jobs that employees were losing because they wouldn't take the vaccine. Employers were using various means to frustrate these employees and had developed various ways, such as these onerous questionnaires that had up to 20 questions to try to defeat these exemptions. We told you about the example of Ascension Healthcare, who I had understood and denied every single religious vaccine that had been presented to them. Following the hearing, a nice lady came up to me and she said, "Will you help me? My husband works for Ascension. He's about to lose his job. In fact, he's scheduled to lose his job today." And I said, "Sure, I would help him. What does he do for Ascension?" And her answer was, "He's a chaplain." And I would just ask you to think about this. A chaplain cannot get a religious exemption for one of these major employers. Think about that. Now, we applaud your efforts to help these employees like this. Anything would be appreciated. We would ask the body here, though, to consider the other people who aren't being taken care of by exemptions. Not everyone can ask for a religious or a medical exemption. There are lots of individuals out there that have studied vaccines, have reason to doubt the vaccine, at least for their own use. They would like to have a little more study of the future and find out if this is really safe and effective. And for those people, we would ask you to make some allowance. In fact, we would ask that they be permitted to have the same rights as the persons who have a religious or a medical exemption. And we would suggest that you add an exemption based upon a person's sincerely held moral or philosophical objections. Please support the Bill 2356, but we would ask that you consider these additions. Thank you.
Thank you. Next, we have Tom Salt, followed by Joanne Atchity. Welcome to the committee, Tom.
Thank you, committee, for being here to hear my testimony today. I work for a government contractor in the Kansas City area and face vaccine mandates. Today, I want to ask two things of this body. First, to echo the previous comments, add a conscientious objection clause, which would provide protection for all Kansans to refuse the COVID vaccine for any reason without fear of loss of their job. And secondly, please change the definition of physician in this bill, or this proposed bill, so that it can allow chiropractors also to sign those medical exemptions. While the current text of the bill is a great start to codifying workers' rights to opt out of vaccines, it fails to address legitimate objections to COVID vaccines for reasons other than religious or medical. The easiest way to address this would be to add a conscientious objection clause, thereby legally protecting a worker's right to object for any reason. The clause would look something like this. Following the paragraph on religious exemptions, paragraph 3 would read, or the employee submits a written waiver request to the employer stating that the employee has a conscientious objection to the requirement. A definition of conscientious objection would be added something like this. Conscientious objection means any religious, philosophical, moral, ethical, or other belief against an employer's COVID-19 vaccine requirement. I would like to present a few examples illustrating the need for this clause. I have a friend who works for a government contractor, a different government contractor in Kansas City, with a wife and 2 kids. He can't afford to lose his job. He has serious reservations about receiving a COVID vaccine, but he didn't feel he had a compelling religious objection, and he didn't have the ability to get a medical exemption, so he ended up getting the vaccine against his will. I have a neighbor who works for the same government contractor. He also has similar serious reservations about getting the vaccine, but he similarly doesn't feel he has a compelling religious reason and no ability to get a medical exemption. He has a wife and 5 kids, and he can't lose his job either. He feels defeated and feels he has no option but to get vaccinated. People are objecting to COVID vaccines for many reasons, which cannot all be encapsulated in a deeply held religious belief or on their medical history. For example, do you think that just maybe the fact that these vaccines utilize novel technology, were hastily developed, and have caused thousands of deaths and hundreds of thousands of serious negative health outcomes just might make some people not want to get them? Or maybe the fact that there is absolutely zero long-term test data. I hold here, as you can see, a roll of toilet paper. What if you were told that as a condition of employment, you had to eat this roll of toilet paper? It might seem like an unusual and perhaps distasteful employment requirement, but it would not be altogether impossible. In fact, if you were to soak this in water overnight and put it through your blender, you could probably down it pretty quick. But who in our society would think it appropriate in any way for an employer to terminate their employee because they didn't eat this roll of toilet paper? Who would think that to opt out of that requirement, you would have to demonstrate a conflicting religious belief or a signed doctor's statement that this toilet paper was going to harm you? I think we can all intuitively know that we have a right to decide what we eat and don't eat. But how is it that when we clearly understand our inalienable right to decide what to ingest, we get so confused about our inalienable right to decide what we inject? Which would be the greater infringement on body autonomy? Requiring somebody to eat some cellulose or requiring somebody to inject themselves with an experimental gene therapy which has potentially fatal outcome. I think it's obvious. I urge the legislature to add a conscientious objection clause to protect every Kansan's inalienable right to refuse the vaccine for any reason. Finally, the bill defines a physician as one who is licensed to practice medicine and surgery. I urge that the language "and surgery" be removed, thereby allowing doctors of chiropractic to also sign medical exemptions. Thank you.
Thank you. Next, we have Joanne Atchity, followed by Brittany Jones. Welcome, Joanne.
Good morning, Madam Chair and committee members. I'm Joanne Atchity. I'm a living woman. I reside in Shawnee. I'd like to deeply thank you all for being here and for allowing our testimony. Before I begin, I would like to deeply echo the statements of all the other conferees so far. Their eloquent words have been deeply meaningful, and thank you for giving each of them your attention as well. Since early in 2020, I have seen COVID-19, in addition to whatever else it may be, as a mechanism of increasing control. Governor Kelly's first act of tyranny was to institute a lockdown, which was demonstrably neither lawful nor justified. Quarantine and even isolation are medical terms. Lockdown is another word for imprisonment. Then in July, Governor Kelly instituted Executive Order 2052, known as the Mask Order. I believe Governor Kelly knew that she did not have the authority to require anyone to veil their face, so she chose to include exemptions. Paragraph 3 of the Executive Order includes 11 exemptions. The following are exempt from wearing a mask or face covering. Of course, that included physical and mental health issues, but I found paragraph 3, letter I, to be most interesting. Persons engaged in an activity or event held or managed by the Kansas Legislature. Rules for thee, but not for me. It is a matter of precedent upheld by the Supreme Court that no man or woman shall be forced or compelled to take any drug or treatment against their expressed informed consent. I have heard much testimony before this committee by attorneys and experts for the state explaining and defending the federal authority to mandate a drug or treatment. Frankly, it has been embarrassing. Just as no authority has the power to inappropriately imprison, compel someone to veil their face, they certainly do not have the authority to compel any unwanted penetration of the body or drug or treatment. As you entered into your current offices, you each swore an oath to protect and defend the Constitution. This bill before us is simply a starting point. I implore you to strengthen it. I call on this body to strongly enforce constitutional protections that recognize and honor our innate, inalienable bodily autonomy and sovereignty. We do not apply for a religious exemption. We invoke it, and it is your job to protect and defend it. Thank you for your attention. I am sovereign.
Thank you. And lastly, we have Brittany Jones, Kansas Family Voice. Welcome to the committee, Brittany.
Thank you for having me today. Chairwoman Erickson and members of the committee, my name is Brittany Jones. I'm an attorney and the Director of Policy and Engagement for Kansas Family Voice, formerly Family Policy Alliance of Kansas. We work on combating government overreach, specifically when it interacts with religious freedom. Now, we don't normally engage on issues of vaccine because we believe that people of good faith can disagree on that issue and can have a solid discussion about how the government interacts on that particular issue. But when a vaccine mandate comes forward and it strongly imposes on people's religious freedom and their right to live out their faith, that's when our organization has to engage. So we appreciate you taking this up and considering RS 2356. We believe that this is a strong exemption that fits into the hole created by all three of the vaccine mandates from the federal government, and it actually helps give employers guidance on how they actually are to go about granting these exemptions. So just to give you a little legal background on religious exemptions as they pertain to government mandates like this, we do know there's a couple guiding principles that we know when we're looking at the freedom of religion. And the first thing is that the government and the Supreme Court has explicitly said in U.S. versus Seeger that they are not allowed to define what a person's religious belief is. And in fact, how they've defined religious belief has been very broad. As long as it's not some sort of mockery religion, the government will recognize it. The government will recognize that belief. And your belief doesn't even have to be recognized by your church or by your pastor. If you believe that is something that your higher power instructs you to do, then we will recognize that belief. The government will recognize that belief. Further, it can be a newly held belief. It doesn't have to be a long-standing belief. This can be something that a new set of circumstances or a new revelation has taught you, and therefore we recognize that belief. So the courts have been very clear that religious freedom is a very broad right. But what we have seen through some businesses recently and also through some government agencies, that they have tried to restrict this right, and they have tried to make this a narrow right. And that is where we believe and we appreciate 2356 because it is the legislature coming in and helping businesses and the agencies understand that we will protect religious freedom in Kansas and that this is a much broader right. So we strongly urge that you would pass this bill when you come to special session, hopefully in a week or so. It fits well within the statutory regulations that we've seen from the EEOC and other areas where there are statutory protections in federal law for religious freedom. And finally, it fits within the statutory framework of the Kansas the Kansas Code that recognizes religious freedom in our Religious Freedom Restoration Act, as well as our the Kansas Act Against Discrimination, which recognize that we have religious beliefs that should be protected. So I strongly ask that you pass RS 2356 when you come to session, and I stand open for questions at the appropriate time. Thank you.
Thank you. Committee, we will now have questions for proponent testimony. Due to time, we will limit each committee member to one question, and if there's time remaining, we will circle back so that every committee member has an opportunity to get their question asked. So, questions for proponents. Representative Barker, then Representative Miller.
Thank you. And this one would be for Brittany. Good morning, Ms. Jones.
Good to see you again.
Have you been able to review the KU and the K-State University exemptions?
I have not reviewed it.
Okay.
I heard some testimony about it, but I haven't seen it.
Would you come and pick these up and if that would
Chairwoman, am I allowed?
Or we can get her a copy? Because
we will have research deliver you a copy. We
Okay.
have extras. Thank you, Dylan.
Because I want you to look at either the KU or the K-State one. And I look at the first one, describe the nature and tenet of your sincerity held religious beliefs, practices, or observances that in the basis of your request. And then what concerns me is the part 2, which they say is optional, not required, and KU also has a part 3. I've always believed that my religious beliefs were between me and my God, not anybody else. So why would I need to go and get some other religious person to attest to my religious beliefs? I mean, isn't that just a little too far?
Well, this is not legal advice. I just have to say that for the record.
I understand.
However, reviewing that and reviewing what I know of the EEOC guidance, which we can debate the full breadth of that later, but even the EEOC guidance and what we know of Supreme Court case law, that question would seem to violate how even the EEOC would look at religious exemptions.
Well, that was my same conclusion, that they may ask the first question, but even though the remaining two are optional, I don't even think we should go there.
They seem coercive by even being on there.
And the testimony earlier that a chaplain couldn't even get a religious exemption also. But shouldn't there also be an accountability of the ones that were approved and the ones that were not approved to see if they're consistent in nature? I mean, if you're going to have these type of exemptions, somebody needs, not just the institution who authors these documents, but someone that would be independent and say, why did you deny this person? And then they may have a cause of action, a civil cause of action. But without that, we don't know what's going on. Would that be a conclusion that you would come to?
That's why I believe that the cause of action that's listed in 2356 is important, because it adds a layer of legal protection beyond our Kansas Act Against Discrimination or our Religious Restoration Act. It adds a layer of protection for the review of these denials.
It just seems discriminatory to me. With that, Madam Chair, thank you for allowing me to ask the question.
Thank you.
Representative Miller, followed by Senator Warren.
Thank you, Madam Chair. And I did have questions for a number of conferees, so I had to pick and choose. But would you put me down for a second round question if we get time? My question would be either for Ms. Mize or Ms. Atchity. Would it be fair to say your position could be summed up by simply saying, my body, my choice?
Would either conferee
You have to at the microphone.
be willing to come to the microphone and answer that question? And please state your name for the record.
Debbie Mize, Lewisburg, Kansas. I do believe in complete bodily autonomy. I do not, however, believe that when I am carrying a child, that I can abort that baby. Does that answer your question?
I think so. I think it's
Thank you.
Yes with qualifications.
Pardon?
I accept that answer as yes with a qualification.
Yes, with a qualification.
Thank you.
Thank you very much.
I do have you down for a second round, Representative Miller, if we do have time. Senator Warren.
Thank you, Madam Chair. My question is for Ms. Jones with Kansas Family Voice, if she would return to the podium. And while she does, I too am concerned with the proposition that we are putting other individuals in the place of judging someone else's firmly held religious belief and being responsible then to their employer for that decision. And do you have any information in your organization that we have done this before in the state, that, or in your experience, has it been if you've asserted a religious exemption that it's granted without the depth of inquiry? Can you speak to that for a moment?
Yeah, I can't completely answer that question because up till now, religious exemptions have been for a very narrow subset of the population. They tended to only affect very few people. But because of the breadth of this mandate and because of the breadth of COVID and how we're dealing with that, it is impacting a lot more people. I don't know if they have been asking these sorts of questions for many years, but it would appear, given their reaction to the fact that there was some questions about whether it was constitutional, the questions they were asking, that this is something they had never thought about and something that they were just used to doing. But I can't speak specifically to the longevity of asking those sorts of questions.
Oftentimes we like to look, has this ever been done before? Is this unprecedented? And things like that. I think that was my one question. So thank you, Ms. Jones. Thank you, Madam Chair.
Representative Miller, we will circle back to you for a final proponent question.
That was quick. Thank you. Of Mr. Heald. And sir, by nature, I'm a libertarian, not by party, but by nature. So I agree with most everything you say, including your call for liability against those that impose vaccinations. My question is really for the chair, and that is, will we have an opportunity, Madam Chair, when we get to that portion of today's agenda that says committee discussion and recommendations, to offer recommendations in addition to the two bills that we're looking at? Otherwise, I would like to have a draft, but I don't want to waste the reviser's time drafting something if we're not going to have a chance to consider it.
Representative Miller, yes, we will. The goal of this committee is to come out with recommendations at the end of this process. So yes, you will.
Thank you very much for that. And thank you, Mr. Held.
Thank you.
Good answer.
My apologies to Representative Tarwater. I missed you. So Representative Tarwater.
That's okay, Madam Chair. I apologize. My hand was kind of slow. My question is for Thomas Salt.
I can't tell you what brand of toilet paper it was, sorry.
Yeah, Mr. Whipple would tell you not to squeeze the Charmin. Anyway, you had mentioned in your verbal testimony, but I didn't find it in your written testimony, you had some suggested wording for closely held religious beliefs and also for medical exemption, and those piqued my interest. And is there a way that you could email that to the chair or to the reviser so that we could look at that later in our recommendations?
Yeah, what's the best email address?
We'll get it to you. We'll get it to you.
Okay, sure.
Okay, thanks.
Thank you.
Seeing no other questions, we will move on to neutral testimony. First, we have Dan Murray, followed by Bob Talley. And Dan is with the National Federation of Independent Businesses. Welcome to the committee, Dan.
Guess we're on here. Madam Chair, members of the committee, my name is Dan Murray. I'm the Kansas State Director for the National Federation of Independent Business. I am paid to be here and proud to do so on behalf of the over 3,000 small business owners who can't take their time away from their business to come here in Topeka. And here to share our concerns on behalf of the state's largest small business association. We have no position on the religious or medical exemption. We encourage you to do what you can to do the best for the people of Kansas. But we do have concerns about the new cause of civil action that has been provided for in this legislation. Small business owners do not have in-house attorneys. They can't afford attorneys to combat the many lawsuits that they might face. And we fear that this bill puts potentially small business owners in the unenviable position of fighting the federal government and OSHA and all the power they have, and also trial attorneys who are certainly looking for opportunities to make money off of our vulnerable small business owners. Let me be clear, NFIB stands against any mandate. In fact, on Tuesday, we filed a lawsuit challenging, a legal challenge to the federal Biden mandate OSHA rule. We stand against any mandate that violates the freedom of small business owners to independently operate and grow their business. This fight is not with employers in Kansas. This fight is not with small business owners in Kansas. This fight is with the Biden administration. And I think that these committee members and the good folks behind us need to remember, we cannot place the burden of the fix to this problem on the backs of the small businesses in Kansas. It needs to be borne by the federal government. Let them fix it, and I think the court's going to work that out. That being said, we obviously appreciate the scrutiny of this mandate and the mandates that the Biden administration has put down by this committee. Look forward to the good work that you can provide. The challenges of these mandates are certainly particularly difficult in light of inflation, gas prices, supply chain challenges that we're seeing as we head into the holiday season. We don't want to exacerbate those challenges with anything that might lead to additional burdens, legal challenges on small business owners. Finally, I just want to point out the Kansas Supreme Court recently threw out the non-economic damage caps on business liability. Non-economic damages certainly impacts the business liability climate in Kansas. Trial attorneys, I'm sure you've seen on TV, are starting to advertise more and more. The waters are churning, and certainly we don't want to chum the waters with any additional bait for trial attorneys to come to Kansas and sue our small business owners. With that, Madam Chair, I'll close.
Thank you. And if you would be willing to stick around for questions after our next conferee, that would be much appreciated. Thank you. Next, we have Bob Talley. Bob, welcome to the committee.
It's good to see you all again, and thank you for allowing our voices to be heard. While I support this bill, I believe this falls short of what needs to be done to protect the citizens of Kansas. Personal autonomy has been a protected natural right that holds precedent in the Kansas Supreme Court and should be protected under the same laws that protect against discrimination due to race, gender, or religious beliefs. It appears that Senate Bill SB 212 and 213 attempted to do this with respect to employment with the language that states, "It is an unlawful employment practice to engage in any adverse employment action against a person because of such person's decision to receive or not receive a particular immunization." I strongly believe that these protections need to be clarified in discrimination law due to the growing efforts to restrict commerce and employment due to injection status. Imagine being a graduating college student who has chosen to not get injected and has no intention of being injected, being restricted from seeking employment due to their injection status. This is where we're at, and we should not abandon the efforts to provide these protections. However, I understand the political aspects associated with either getting the governor to sign a bill or coming up with a veto-proof vote. Time is of the essence. At a minimum, I believe that the following should be added to the specific current bill. I'm going to second what Tom Salt said with respect to conscientious objection. I think many of our youth today have grown away from the institution of church and religion in general, but they still have a strong moral conscience that they can't jump into the religious exemption language, and I've counseled many people that it really does apply, but even employers have struggled to go to that point. So I think clarifying conscientious objection would be a great alternative. How about no physician shall be restricted from providing medical exemptions, including providing exemptions that are not listed by the CDC as an acceptable condition sufficient for exemption. Any medical group, employer, or certifying association found to be discriminating against doctors providing said exemption letters shall be subject to a $50,000 fine. All pregnant women or women anticipating pregnancy are automatically medically exempt without a physician letter. All employees with natural immunity are automatically medically exempt without a letter. All young men 30 and under are automatically medically exempt without a physician's letter. You know, they've canceled distribution of some of these vaccines overseas to these young men because of the concerns with myocarditis and pericarditis. Finally, outside of the exemptions, employers must give all employees, exempt or not, the option to choose testing, PPE, or work from home where applicable as an option to taking the vaccine at no cost to employees. No educational institution may require the injections, period. There are no protections afforded to students as currently drafted without going to court. No physician shall be restricted from providing medical treatment, including administering hydroxychloroquine and ivermectin while practicing inside of any hospital, urgent care facilities, or emergency rooms. Any medical group, employer, or certifying association found to be discriminating against and restricting doctors from providing medical treatment shall be subject to a $100,000 fine. To incentivize employers who violate these provisions will be fined $10,000 per violation for small businesses and $50,000 per violation for large businesses. I trust that while all these may not be able to be addressed in special session, they will be considered when you get to regular session. Thank you.
Thank you. Committee, we're going to hold questions till after opponent testimony for neutrals. So first opponent is Eric Stafford with the Kansas Chamber of Commerce. Welcome to the committee, Eric.
Good morning, Madam Chair and committee members. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber, and do appreciate the opportunity to testify in opposition to both proposals. I'll focus on just this one. I apologize that all my testimony was kind of lumped together as I drafted it, kind of unsure how this process would go. But really focusing this first piece, and I'll say this again this afternoon when we speak on the second one, that we are being placed from the employer community in the middle. We did not ask to be here. The Biden administration put us here. I testified a few weeks ago before this committee that based on the survey results that we had received up to that point from our membership, 97% responded saying that they were not mandating and had no intentions to mandate the vaccine for their employees. But ultimately, we do not support mandates, just like Mr. Murray spoke. We do not want mandates from either side, even what could be kind of perceived as a reverse mandate. But real quick, these bills place us in a tough position. We spoke a few weeks ago about supporting the Attorney General in his efforts. He's now filed a lawsuit on the healthcare mandate. He's filed a lawsuit on the federal mandate for contractors, and then he's also filed and joined lawsuits on the OSHA mandates. And we will continue to support as much as we can and to as much as our ability allows as an organization the Attorney General's efforts to remove those mandates from the business community. Our objection to this piece largely is about the new cause of action and the expansion of liability on businesses under this proposal, with included the collection for attorney's fees and allowing employees to sue their employers for rejecting or not granting a waiver based on medical or religious beliefs. Some of the feedback we received over the last few days on this specific piece, that this is basically putting, the way it's crafted currently, circumvents the current established process for review of religious and medical accommodation requests, and it's contrary to the federal EEOC guidance and existing state discrimination claims review process that's under KSA 44-1001, which the Kansas Human Rights Commission is tasked with the enforcement of the Kansas Act Against Discrimination. It's unusual and not common. Our folks could not find anything specific that grants the ability, an employee the ability to request a medical exemption based on a family member. The exemptions today must be based upon the potential adverse health effects of the individual or the employee, not a family member of the employee. So just some other legal considerations and concerns that were brought forward from us or to us as we have been gathering feedback on this. But largely, in terms of the waiver piece, those are our comments there. But our objection largely is over the expanded liability and the new cause of action that you guys are creating. And this, we have great concern over that. We're doing what we can. Again, we didn't ask to be here. We were thrown in this, and the Biden administration is putting it on our backs to enforce the mandates that they want to enforce, and we didn't ask to be here. So we ask that you not punish us from the Kansas business community for only carrying out what the federal government is trying to carry out, that is being litigated on many fronts and in many states at this time. So happy to answer any questions at the appropriate time. Thank you, Madam Chair, and committee members. Good to see you all.
Thank you. Next, we have Kelly Summers from the Kansas State Nurses Association, followed by Michael Papa from Mainstream Coalition. Welcome to the committee, Kelly.
Thank you, Madam Chair, and thank you, committee, for the opportunity to be here to speak on behalf of all of our members of Kansas State Nurses Association. This is a very difficult time, and I honestly didn't think I would be here ever in my past to have this conversation with any of you, and I'm sorry this is where we're at. Kansas State Nurses Association is a not-for-profit association, and I want to make that clear that we do not have a PAC. We make no contributions to anyone at the state level, and that myself, I am not a lobbyist, and this is the first time I've actually came here to testify at the state capitol. With that, we'd like to thank all of our Kansas nurses who early on, the thousands of nurses who got vaccinated, all of the nurses who have been providing care to COVID patients, holding the hands of those who have died, being there for those people and continuing to provide care with those who have ongoing disabilities from COVID-19, and to be there to educate and advocate for every single person in this room's behalf. That's what we do as nurses. We always, when we enroll in nursing school, it is our priority to get a vaccination. We get a vaccination not just then, but we continue to practice and get vaccinations, not only to protect us, but we are there to protect every single person in our community, because that is who we serve. Nurses serve our patients and our community. And that is why we are here. And to take the COVID-19 vaccine and to pretend like any mandate can then be a concern right now, it's just a requirement to add a vaccine as we practice nursing. When it comes to the patient, we are going to look at this from a different perspective, because it is our job as nurses to actually sit there and to counsel our patients, but ultimately our patients make their decisions. We don't make the decisions on behalf of patients. That must be clear. Do we like what came from the Biden administration right now? Absolutely not. These CMS guidelines that wants to take away Medicaid and Medicare funding from our institutions that provide care to people is wrong. It is wrong. Our long-term care has suffered since last year. And to sit here and think for a solitary second that that money should be taken away right now, it's not going to work. Our economy is going to fall. Our people are going to suffer, and we will not stand for it. So I thank you so much for the opportunity to be here today. I appreciate there's been conversation regarding safe staffing, and I hope that we can have conversations in the future to address those specific issues also. Thank you.
Thank you. Next, we have Michael Papa from Mainstream Coalition, followed by Rachel Monger from Leading Age Kansas. Welcome to the committee, Michael.
Thank you, Madam Chair, members of the committee. Appreciate the opportunity to address you today in opposition of RS 2356. Mainstream Coalition was founded in 1993 by a bipartisan, multi-faith coalition of community leaders on the right of religious freedom and equitable representation in our government through separation of church and state. Now, this principle has guided our work in Kansas for nearly 30 years, and we believe very strongly that there is no place for either the church to govern nor the government to impede on religion. This is why we oppose Draft Bill RS 2356, which makes a mockery of this sacred position. Specifically, Section 1, Paragraph 2B. An employer shall grant an exemption requested in accordance with this section based on sincerely held religious beliefs without inquiring into the sincerity of the request. This is an unnecessary solution in search of a problem. Federal government, Kansas already has robust protections that provide for individuals who seek religious exemptions. The current draft sets a dangerous precedent, and it potentially opens the floodgate by eliminating the existing ability of an employer to verify a spurious claim of sincerely held religious belief. And in truth, this bill circumvents a private employer's rights to protect their staff from a public health crisis and endangers their livelihood by creating undue hardships to accommodate unvaccinated individuals in the workplace. In fact, the EEOC guidance states that there are instances where an employer is justified in seeking additional supporting information. If we lived in a society absent of flagrant misinformation campaigns regarding vaccines broadly and COVID-19 specifically, then this draft bill wouldn't exist. Unfortunately, that's not our reality. Instead, we're seeing religious exemption requests increase despite the lack of religious leadership calling for such opposition to vaccines. We live in a hostile political climate, and we're seeing that the request for religious exemptions can and will easily be conflated with personal and political opposition. I'm not a lobbyist. I'm a Kansas resident. I'm an employer, an elected official, a son, a husband, and a person of faith. And I feel obligated to speak out against this proposed bill that will undermine the integrity of separation of religion and government. Further, I strongly oppose any attempt to expand this bill to include such lax provisions for parents wanting to exempt their children from vaccination without verifying sincerity. One of our members wasn't able to submit testimony, but he did write me, and I thought this was pretty profound and you should hear it. To write a law using a religious exemption in this way uses religion as a disguise and smokescreen for unlimited exemptions. If you want unlimited exemptions to a law or rules, bypass it. Don't use religion as an excuse. Mainstream Coalition stands in opposition to RS 2356 in its current form, and we urge this committee to strike Section 1, Paragraph 2B prior to further discussion. Thank you. I appreciate your time and consideration.
Thank you. Next, we have Rachel Monger from Leading Age Kansas, followed by Darren Duffy. Welcome, Rachel.
Thank you very much, Madam Chair, and thank you all for allowing us to be here to voice our concerns today and offer testimony that I'm not thrilled to be offering because, as you hopefully saw in the testimony we submitted to the committee in your first round of hearings, Leading Age Kansas strongly opposes the CMS vaccine mandate rule. We are pro-vaccine, and many of us agree that in an ideal world, every resident and staff person who can take the vaccine would do so. Unfortunately, we aren't living in an ideal world. We are, in fact, living out a nightmare scenario of an ever-deepening workforce crisis and financial instability that is threatening the care of seniors all across the state. We have lost thousands of jobs in long-term care during the pandemic. 60% of our members are denying new admissions due to lack of staff. 68% are reporting serious financial instability. 2 of our members announced their closure in the last month, specifically citing the inability to find staff. And if something doesn't change quickly, that number will continue to grow. We now have a government mandate that in just a few short weeks will force our homes to banish another 1,000 or more people from our workforce in Kansas. And that 1,000 is under the best case scenario cited by CMS as no big deal. We are stretched so thin that in some organizations, all it takes is for one more nurse to leave and they're done for. I talk every day to nurses and administrators in nursing homes who've not had a day off in a month and putting in 100+ hours a week in a desperate attempt to keep their residents cared for and buildings open. This is the wrong policy. Unfortunately, absent a success in Attorney General Schmidt's recently filed lawsuit, our long-term care providers must comply. 70% of our revenue is Medicare and Medicaid, and without federal funding, we do not have long-term care in Kansas. CMS carries an extremely big stick, and they know it, and they use it seemingly without limit. And that's why I'm forced to be here today. We are very concerned with the proposed new language around vaccine exemptions, and most especially the language on medical exemptions. The CMS rule lays out specific requirements for medical exemptions, and if those requirements aren't met, the nursing homes cannot approve it. It seems clear that under this proposed legislation, our staff can submit a medical exemption request that meets state law requirements, but would fail to meet federal ones. This puts our providers obviously in an impossible situation of either granting the request and violating CMS regulations and losing federal funding, or denying the request, violating state medical exemption law, and potentially facing the steep costs and litigation from the newly created right to sue. Either option would close their doors. Our second concern is around the religious exemption, and it's really more of a question that we have at this juncture. The CMS rule references EEOC guidance on religious accommodation, and in there, employers are supposed to distinguish between religious belief versus a personal preference or philosophy. And so our question is, would that make it so that our providers would not be able to pursue that line of inquiry under that guidance? So there may not be an answer today, but we thought it was important to ask. So thank you very much again for allowing us to be here, and I'll be available for questions at the appropriate time. Thank you.
Thank you. And finally, we have Darren Duffy. Darren, welcome to the committee.
Madam Chair, Senators, committeemen, and women, really appreciate the time to bring this argument to you. I'm kind of in at odds now. Some people on the proponent side put some really good arguments out there. People on the neutral side, all the opponents. My name is Darren Duffy. I ran for mayor in KCK this past cycle. And the thousands of people that I spoke to, I believe I represent them very well right here, right now. I didn't make the cut, but that doesn't change the representation. The star I wear on my chest is a Jewish star. It's not meant to be offensive. It's not meant to be controversial. It's meant rather to be a reminder. Everything that Hitler did, every single thing that Hitler did, he did in accordance with the laws of his country. And I know that sinks in. I know you guys know this. It's history. And I'm a theology major, history minor in college. So these are things that are true to me. I represent grassroots Kansas people. We are the heart and soul of the country. And while our country is mandating all these things, Kansas as an entity, we have sovereignty here. We have sovereignty to choose and to do what is right for the people of this state. So I'm asking each and every one of you to do the right thing in accordance with the will of the people that elected you. I see before me a lot of experience, and I also see a lot of hope. I really do. I see people that know the right thing to do, and you have the power and the will, the capacity to do it. And I'm asking that you do it. To be clear, to create exemptions for these mandates is to give viability to a mandate. These mandates, they stand in opposition to our constitutional rights. They stand in opposition to our personal sovereignty. You all know it. We all know it. This is my body. And whether you use the phrase, my body, my choice, that the abortion industry has adopted, it is my body. I have sovereignty and autonomy, not based on what men have told me, but based on what God gives me. That right, that simple right to say no, is my right. Nobody has the right to impose their opinion or their fear on me or the people that I represent. So I ask you again, strike this bill down and any bill like it. Step away from mandating anything that involves taking the sovereignty of man away from him. Do the right thing for the people of Kansas. I know you will. I appreciate your time. Thank you.
Thank you very much. And committee, again, we will go one question until we see if there's time enough for Other questions? Representative Carmichael, my apologies if your hand has been up a while. I was just informed you do have your hand raised, so we'll start with Representative Carmichael. And this is for neutral and opponent testimony.
Thank you, Madam Chair, and no apology necessary. I thought I would just get my hand up after I heard Mr. Murray's testimony. And so with Mr. Murray and the chair's consent, I wonder if he might now stand for my one question.
Madam Chair, Representative, happy to.
Good morning, Dan. Nice to see you again. I think Mr. Stafford made clear from his testimony the position of the Kansas State Chamber of Commerce that with respect to 22 RS 2356, they have grave concern and opposition to the provisions of Section 1, subparagraph C, which includes 1 and 2. And as I heard you testify, I believe you were telling us that your members and the small businesses that you represent have objection to Section 1, sub C, paragraph 1, and that's the provision that says even though the federal government tells an employer they must do this, they could find themselves on the horns of a dilemma because the state law would tell them, no, you can't do this, instead you should do that. And I'm oversimplifying, but that puts you in an impossible situation, because if you follow the federal laws or regulations, the employer is responsible not only for injunctive relief, in other words, orders telling the employer from a court that they must obey the state law, but also the actual damages, which is a financial burden. But I want to direct you specifically, though, to sub C, section 2. And for convenience, it provides in an action under this section, the court shall award a prevailing plaintiff the cost of the suit, including reasonable attorney's fees. Now that looks to me like if a small business gets sued for complying with federal law in violation of state law, that the state or the small business is going to be responsible, 1, for being placed under an injunction, 2, paying the actual damages of the employee if the employee is successful in the lawsuit, but 3, you not only have to pay your lawyers, you have to pay the the employee's lawyers as well. Is that something the National Federation of Independent Business thinks is a good idea, not only in the context of COVID, but as a general principle that employment law lawsuits, we ought to make the small businessman responsible for their own lawyers' fees as well as their employers' fees? And if you don't think that's a good idea, perhaps you could explain to us why not. Thank you.
Thank you for the question, Representative. Our general concerns, and you've summarized the provisions in the RS that we have addressed our testimony to, are the notion that we are creating a new civil cause of action that small business owners will have to contend with. As I said in my testimony, small businesses don't have in-house attorneys. It's hard to afford expensive attorneys like Mr. Carmichael in Wichita and others. And so the resources for small business owners to contend with these potential litigations often lead to settlements, which increases their cost of doing business, et cetera. So we're concerned about the new cause of civil action. As part of the way this bill is written, yes, the plaintiff receives the loser, in this case, the small business owner, would have to pay the plaintiff's attorney's fees. One suggestion maybe could be that if the plaintiff were to lose, they would pay the small business owner's attorney's fees.
Well, I only have one question, Mr. Murray. I might point out to you that while my fees may seem high, I too am a small business person, and I'm very concerned about having to comply with a federal law, a state law, and pay my employees' attorney's fees. Thank you, Madam Chair.
Next, we have Representative Owens, followed by Senator Thompson.
Thank you, Madam Chair. And Dan, while you're standing there, first of all, back to your testimony, I couldn't agree more that I hope that our Attorney General prevails in ending every one of these, what I believe are unconstitutional mandates. That would have prevented us from being here and certainly wouldn't put us in this type of a predicament, because we realize that. As a small business owner myself, thankfully having less than 100 employees at this time, my question to you is, as you have polled your members, I assumed you've polled your members or something along those lines to speak on their behalf, do they not plan on granting medical and religious exemptions?
Absolutely, I'm sure they will.
Then why is a cause of civil action a concern? Because the only time that comes into play is if they don't grant a religious or medical exemption as prescribed by law.
If the other side of this equation is the federal government with the massive OSHA machinery and mechanisms that they can bring to bear to also squish down on the small business owner as well. So again, the small business owner has to choose, am I going to comply with the Biden administration's OSHA and their big gorilla, or am I going to get sued by my employee? And that puts them in a squeezed little situation where some employers may throw their hand up and go, I don't know what I'm going to do. And so there's some confusion here when we try to mix federal and state law in this particular way. We don't know that OSHA will accept the religious and medical exemptions as written in here. I sure hope they do. But in the meantime, there's certainly some uncertainty among the small business owners about that threat of either OSHA or a trial attorney.
And to follow up on that, and I quote, the federal government will defer to contractors to determine when the employee has a sincerely held religious belief or medical condition that requires accommodation, according to senior administration officials. So it indicates to me that they're going to allow the business to make that decision. So to bring this full circle, if they defer to the business and your businesses intend on granting medical and religious exemptions, then there's no cause for civil action. Am I understanding that correctly?
If that reading is accurate, I hope that to be true, and I'll put my full faith and credit in the President's administration.
You're braver than I am. Thank you. Thank you, Madam Chair.
Senator Thompson.
Thank you, Madam Chair. So many questions, so little time. I think I'm going to pick asking Mr. Stafford one quick question.
Hi, Senator.
How are you doing, Eric?
Good.
I think you mentioned that 97% of the Chamber's members were going to accept or not mandate the vaccine or accept the exemption. Is that correct?
Based on when the Biden administration announced their mandate, yeah, that's when we started putting out our survey to confirm what we had been hearing through phone and email conversations with them.
Can you give me a general overview of the 3% who intend on mandating? Are they large employers? Are they federal contract employers?
We wanted high participation, so we asked very few questions. We didn't break down in terms of the number of employees of respondents, what industries they were coming from. I would entirely agree with Dan's analysis on Representative Owen's questions. And I think, too, I would add each employer's circumstance is unique and different. And so that's why on all sides, a one-size-fits-all approach. We might have some employers who are accepting religious and medical exemptions, but we might have some who are not within our membership. So, but that's ultimately why we just continue to maintain the position that we feel like our members were doing as good of a job as they could prior to, and this really wasn't an issue until the president did what he did, and we either face litigation or we face minimum of $15,000 fines from OSHA per employee per incident. So we're stuck between the rock of the federal government and the hard place of state government.
And I'm sure you've heard the other conferees and the proponents. Time is of the essence for them, too. They're about to lose their jobs. Yeah. Thank you, Madam Chair.
Senator Warren.
Thank you, Madam Chair. Thank you, conferees. My question is for Mr. Murray. Briefly, I want to first follow Representative Owen's comments that I, too, am thankful that the state of Kansas is taking on this challenge through our Office of Attorney General, and who has, through the Attorney General, has filed several lawsuits. And you mentioned one that it sounds like a member of your organization, a business, has filed against the Biden administration. I'm just wanting some more details about it. Has your member as a private company sued the Biden administration? And if so, were the same sort of arguments made in that lawsuit that our Kansas Attorney General has made against the Biden administration too? Because I think we have to remember that kind of the common, what we're all looking at is coming from the Biden administration. So if you could expound a little bit about what's happening in that lawsuit.
Absolutely. Thank you, Madam Chair. Senator, NFIB, let me plug them real quick. We're a member organization, but also we have an advocacy arm both in D.C. and the state capitals. We have a research foundation that does a lot of good work around what small business owners think and feel and survey the impacts of these kinds of mandates and what they mean to their employees. And then we have a legal foundation as well. The legal foundation joined in with several other business organizations and filed a legal challenge against the OSHA temporary emergency order on this Tuesday. Just like my small business owners, I don't have an attorney with me today to tell you exactly the merits of their argument, but essentially they said that OSHA rule, that they used it too broadly, too widely to impose this mandate. They ignored public comment, and there were some other arguments that are part of that legal challenge.
That OSHA probably didn't have the authority that they
Essentially,
claim that they do.
Yes,
right. And knowing you're not an attorney, appreciate the summary there. I think that's kind of the discussion we had another day in committee here, that does OSHA have the authority to do what they've done? Does the Biden administration have the authority to do what they've imposed? And we're working our way through that in the courts, and obviously this body's looking at other resolutions as well. So thank you, Madam Chair.
Madam Chair, I just real quick, and I hope, the OSHA rules, since we're talking about OSHA, certainly applies to those 100 and above. There is some discussion that they may reduce that number from 100 and go lower than 100. A lot of times in law, it's 50 or fewer employees are exempt from these kinds of things. So we have concern that this could progress and morph over time. The discussion that we had about what is a contractor, who's impacted by federal contracts, those go down to the smallest level, not just 100 and above. So again, we appreciate the scrutiny that this committee is giving. As I've stated, we challenge those mandates, the validity of them. They're very dubious at the federal level. So we stand with you in that regard. We just want to reiterate, it's difficult being put in the position of having to choose between the OSHA gorilla and a trial attorney attempting to sue us for something, again, that we had nothing to do with.
Senator Petty.
Thank you, Madam Chair, and this is for Mr. Duffy. Mr. Duffy, I actually hate to give you the attention, but you came forward today wearing a star, and I'd like to hear the reasoning again why you're wearing that.
The reason I'm wearing the star is, as I said, it's not to be offensive, but it's to remember, and for everybody else to call to remembrance. World War II, the Jewish people were forced to wear a yellow star to identify them as Jews. And they were ushered off to the death camps in accordance with that. There were medical tests, there were experimentations done on human people. And while this hasn't reached that deprivation, we are definitely moving in that direction. We're definitely moving in that direction. When has anybody had the right to tell you what?
Mr. Duffy, I'm not asking for I asked for one thing about the star. I did not ask for a speech.
Yes, ma'am.
So I'm going to say to you, you are not respecting Jewish people when you wear a star like that. You are desecrating that memory. Millions of people were killed. We're not talking about millions of people being killed here. So I think you need to be respectful to Jewish people. No, there have
Okay,
been over 760,000 people
I'm gonna
killed
call
by
order.
COVID.
Senator.
So please sit down with that and
Senator.
take that off.
Senator, you asked the conferee his opinion. He gave it. Thank you very much. Senator
I
Masterson.
think we have a right to be respectful to the Jewish
I agree.
tradition.
Both committee members and conferees need to be respectful. Thank you. Senator Masterson.
Thank you, Madam Chair, and thank you for keeping order. I had one quick clarification I'd like from Kelly Summers, and then I have a question for Eric Stafford.
Hello, Mr. President. I had a feeling you were going to come for me.
Well, my daughter's
I know she
an
is.
RN, and we heard from several nurses in prior testimony, like clear back to the 9th. So I just want to clarify, did you poll your membership or have a board vote? You represented that you spoke for.
A long time ago, but this was prior to the whole Biden administration piece, because quite honestly, we all know this hit us fast. But, and I have been polling throughout our whole time in COVID, and I honestly have to tell you, most nurses have gotten the vaccine, and this is for them not their primary issue about whether the state
I don't mean to
of
cut you off, but
Kansas
the only
puts this
point of
forward.
clarification was you spoke on behalf of all your members, and in your testimony, that's 40,000 RNs.
No.
So you're not, so that's the clarification I wanted. You're not speaking on behalf of all your members. This is the fact that
No,
you don't support exemptions for any immunizations other than medical, that's not a formalized stance of your association. That's your contention.
It's not my personal, it is the Kansas State Nurses Association.
That's
and
what I'm
the
asking.
board.
You polled, and that is a formal stance of the
I've
Kansas
actually
State
had
Nurses Association.
conversations with those who are not just members throughout this too, because I've given the opportunity for others to speak, because I
Maybe
don't think it
misunderstand my
would be fair.
conversation. You actually formalized, had a vote of your membership, had a board that this is the stance of this association.
Yes.
I would like to see those
I
results.
actually have the vote, and I also have, we had a membership assembly back a couple weeks ago, and I actually do have those results, including also our new legislative platform for 2022.
I would like to see those results.
Absolutely. Anything else?
Nope, that was it.
Thank you.
Eric Stafford.
Hi, Mr. President.
Hey, thanks for coming in. And really, I mean, I have a whole list of questions, but time is short. But I really only have one that I think gets down to the issue we're trying to tackle. And that does the chamber, or have you put a dollar value on the religious right of an individual? I mean, if what we do now only costs a few $100s, are we good? If it's $1 million, is it worse? If it's $100 million, we don't. Is there a dollar value on the religious freedom of an individual?
I don't know if I can answer that question, Madam Chair.
But the chamber doesn't have a formal stance on, we think there's a dollar value attached.
No.
Okay. Thank you, because I think there's a lot of misunderstanding, right, and this kind of false choice, thank you, Eric, that somehow you're in conflict, federal and state, right? I think that's why we've taken this so narrow. You actually comply with both. Federals have a mandate. We honor the exemptions that they've recognized as possible. So I think we're trying to red herring this deal, and we really need to get back to focusing on the fundamental right of the individual, of which I don't believe there's a dollar value. We've heard that from one of our other committee members, that somehow there's some dollar value attached. And if it comes to any question, I believe we should certainly be erring on the side of the fundamental right. Thank you, Madam Chair.
Thank you. Obviously, we are running behind schedule. We are going to try to make up a little time over our lunch. Committee members and staff, you know the drill. Lunch has been provided. We are going to recess until 1:15, and then we will take up our afternoon agenda. Thank you. Okay, welcome back. Hopefully everyone had a good lunch. We're going to go ahead and start the afternoon. We're going to begin with an informational hearing on Bill Draft RE 2357 from the Revisor's Office. Jason.
All right. Thank you, Madam Chair, and welcome back from lunch, committee. So you have RS 2357. That's the draft that was distributed the other day. You now have a more formal memo overview of what I presented to you that day. So I'll try not to go into too much detail. But essentially, this is the draft you were looking at that would provide exceptions to unemployment benefit eligibility rules for otherwise eligible claimants who left work or were discharged for refusing to comply with the COVID-19 vaccine requirement after being denied an exemption, and retroactively also provides benefits for such claimants who were denied benefits. You've got 4 sections, all amendatory. The first is just the definition section. We got the definition of, it's on page 31 is where the definition changes to define vaccine requirement, and also to define COVID-19 vaccine, just as you saw in the prior draft. So those are in there because they're used throughout this bill. Section 2 of the draft gets into the statute concerning eligibility for benefits, and I kind of outlined this a little more thoroughly in the memo, and also the other day I gave you a little bit of this, but under current law, you know, you've got some general rules that you're eligible if you meet certain requirements, and there's a new provision in this statute that says an unemployed claimant otherwise eligible for benefits will not become ineligible for benefits by declining to accept work that requires compliance with the COVID-19 vaccine requirement if that individual requests an exemption or accommodation and that's denied. So we have that language in there. And I'll point out, just as a little bit of background, because I was reminded this by the folks in my office that actually staff this subject matter, and who are here to help me if you get into the weeds a little bit on this issue. The reminder is that it's possible, but certainly not clear or certain, that under the current law, the Department of Labor or a board of review or a court could determine that some of these things already exist under our employment security law. So in a way, this is adding some clarity or certainty on these issues. And so I just wanted to be clear that it's not like the Department of Labor has come out and said none of this can happen under current law. You know, we don't know that for sure. So I didn't want to give the impression that this is a certain thing under current law. So that sums up section 2 and gave you that caveat. Section 3 of the draft then is kind of the big section that has 3 different amendments in it. This is the one regarding disqualification from benefits. So you've got subsection A that disqualifies you on one ground, and we carve out an exception for an individual who left work because of a COVID-19 vaccine requirement after requesting an exemption and being denied. You've got subsection B that has a different disqualification from benefits, the same carve out for someone who is discharged for refusal to comply and meets those requirements we mentioned. And finally, you get a subsection C, a general rule about being disqualified for not seeking suitable work or accepting suitable work, and we have a carve out for the situation where the work you're offered requires a vaccine requirement and you ask for an exemption and you're not allowed that exemption, and so that work is then deemed not suitable for you, so you're not disqualified from benefits. So all 3 of those are in section 3 as different pieces regarding disqualification from benefits. And then the final subsection or final section of the draft is the one concerning process and procedure for benefits claims. So we had a new subsection way at the back on page 65 that gives retroactive benefits back to September 9th of this year for any week that the claimant would have otherwise been eligible if they meet the criteria that we've been talking about all along. They were discharged, you know, they left employment or were discharged based on a COVID-19 vaccine requirement compliance issue. They requested an accommodation, they didn't get one. And I note that the date chosen was the date that the executive orders and the proposed agency actions were announced, September 9th of this year. And then the last thing I'll point out in that subsection at the end of section 4 is that the claimant can make a request, but the Secretary of Labor is also required to go back and review some of these cases that might qualify in order to see if they're eligible for retroactive benefits. The appeal process is preserved. You are allowed to appeal that award just like you are any other award under current law. And the Secretary is going to develop some procedures to enable this process to happen. So that authority is there as well to facilitate implementation. With that, I hope that gave you enough of a reminder from the discussion the other day, and I'll see if you have any questions.
Thank you, Jason. Questions from committee members? We have Representative Carmichael, then Representative Miller.
Thank you, Madam Chair. Mr. Thompson, I apologize if I overlooked the electronic copy of your, I guess you'd call it an RS brief. Just preliminarily, has that been distributed electronically, if anyone knows? So, because I need to get it in front of me and I can't seem to find it.
Madam Chair and Representative, yes, I did provide that electronic copy, and it should be available. We're going to double check to make sure it is.
Yeah, just give me a rough time frame. Do you know about when it went out so I can look for it?
Madam Chair, I believe it was just posted on the committee documents. I don't know that it was sent to the committee directly, but we can certainly forward you a copy directly right now.
That would make it a lot easier. Thank you. My substantive question, and I do not have the case in front of me, but you had addressed the matter that it is possible that under some circumstances, folks may be entitled to unemployment benefits already, which would also be within the scope of this expansion of unemployment benefits. I think there is a case, Unemployment Board of Review versus McPherson Hospital, as I recollect. It's a Court of Appeals case, and there's the ROS memos for today. Thank you. But that particular case, based on the facts of that case, I believe the Court of Appeals found that an employee who refused a flu vaccination at a hospital had violated without a sufficient, I think in that case it was a religious exemption. No, it wasn't. It was a medical exemption. But without a sufficient exemption, could be terminated as a result of a violation of an employer's work safety rule, and hence they were not eligible for unemployment. I think that's probably the leading authority in Kansas on point, but I know you have additional staff there and I may be mistaken. Can you or your staff refresh me on the status of the law as it relates to that case or any similar cases?
Madam Chair and Representative, yes, we have some additional staff members here, so I'll turn it over with your permission to Charles Reimer from our office.
Always a pleasure to hear from Mr. Reimer, certainly.
Thank you, Madam Chair, Representative. So the point that Mr. Thompson was making was just that the circumstances of being discharged for refusal to receive a vaccination would be something that could be handled on a case-by-case basis under current law. And as you know, as he pointed out, as you pointed out, you know, the issue is whether it would constitute a good cause if the employee voluntarily left, or whether it would be determined to be misconduct if the employee was discharged. And typically that's looked at on a case-by-case basis. And I have read the case that you referenced. It's been some time. I'd have to go back and look at it again. But I think the point is that simply that based on case law and based on the Department of Labor's considerations, the issue can be addressed under current law. That's all that Mr. Thompson was trying to say.
Thank you. I won't belabor the issue any further. I might somewhat disagree about the impact of precedent, but today's not the time for that discussion. Thank you, Madam Chair.
Representative Miller.
Thank you, Madam Chair. And just follow up on that point, that's exactly what KDOL told us Tuesday in their testimony, was it'd be case by case, which really told us nothing. I don't have a question, but I did want to alert the chair that I do have an amendment when we get the opportunity to discuss this bill. I wanted to bring it up now so that it could be sent to the committee electronically. I only have one hard copy, and to the extent we can get notice to the other members, could we ask the reviser to please send out my amendment, even though I don't intend to offer it right now?
I appreciate that, Representative. And just to remind the committee and those in attendance, this is not a formal bill, so these are not amendments. They're recommendations to the draft language. And yes, if we could get that distributed, that would be much appreciated. Thank you, Representative. Any other questions for Jason? Senator Petty.
Thank you. And Jason, these may just be covered in current law, but when I was looking over the bill, I wondered, it's on page 33, does the employee need to be employed for any period of time to be eligible, or is that just falls under current law with unemployment?
Madam Chair and Senator, yes, so all of the normal rules for unemployment eligibility apply with just these few carve-outs or exceptions. So there is probably a period of employment required, and I see my fellow staff person looking for that if you want to know the specific number.
No, that's okay. I did have a couple of other questions. Would the claimant under the current bill, would they have an extended period of time for unemployment other than anybody else filing for unemployment?
Madam Chair and Senator, no. My understanding is that they are subject to all of the normal restrictions on the number of weeks you can claim. And some confusion maybe comes from the retroactivity piece, right? But the retroactivity piece is worded such that you're allowed to go back and claim benefits for weeks you were otherwise eligible. And if you were able to claim enough of eligible weeks and you hit your limit, you're done with benefits just like any other person, right? So all the normal rules apply to you with these few extra rules kind of on top of that.
Okay, so maybe this is already covered. What would be an accommodation from the requirement?
Madam Chair and Senator, that one actually is specific here, right? Because it's dealing with the language requiring you to request an exemption or accommodation for not complying with the requirement. So that's your first step. You have to at least show, for the purposes of eligibility, that you made a request for accommodation or a request for an exemption, because we have to assume that bill draft number one we were talking about is not in law, right? This is assuming you enact the unemployment law by itself, right? So you have exemptions or accommodations allowed under current law that Mr. Abbott from our office told you about that are under federal law or state law. So you would have to have said, I have an objection to this requirement, have that denied, either the accommodation or the exemption that you're asking for, and that then makes you eligible for the benefits. So hope that answers.
And maybe that does. And maybe this is current law under page 47, and maybe it was just a rewriting the words good faith. I noticed that good faith was underlined. Good faith errors in judgment or discretion. Is that current law and not a change? It's item number 4.
Madam Chair, Senator, can you remind me which page that is?
47.
Okay. I'm pretty sure I'm recalling that one as a cleanup and not a substantive change.
After I asked it, I thought maybe it was
I want to
cleanup.
confirm. Let me double check. I don't want to misspeak. Yes, so down at the bottom of page 47, I believe it's hyphenated in current law, and our editor said when you're in there, take out the hyphen and make it 2 words. So that's just a Scrivener cleanup. Yeah.
Okay. And then my last one is, and this is on page 49, what if the employee just leaves and doesn't ask for exemption?
Madam Chair and Senator, then I don't think you qualify, right? That's the way this one is written. You have to ask for the exemption and have it denied to meet the language of the statute. Since I've been told I can publicly talk about Representative Miller's amendment, and you'll be seeing it soon, essentially that amendment just removes that requirement. So you would be eligible if you left for failing to comply or for refusing to comply. So if you just left for that reason, you wouldn't have to show that you asked for an exemption under his proposed amendment. So that's why it's there. You have to meet that requirement.
Okay, thank you.
Senator Thompson.
Thank you, Madam Chair. Just real quick, they've changed the number of weeks that can be filed for on unemployment. What is the maximum now for a long-term employee who gets fired?
Madam Chair and Senator, I'll refer to Charles again. I think he's got that ready.
Thank you.
Actually, I'll have to check on that, but we can get back to you about that.
Thank you. Thank you very much. Thank you, Madam Chair.
I'm glad I'm not the only one that wasn't sure. I'm comforted by that.
Any other questions for Jason? Seeing none, thank you very much. We're going to move on to conferee testimony. Conferees, you will be given 4 minutes. You will be given a 1 minute, a 30-second, and a final warning for your time. We will start with proponents. And again, committee, we're going to hold questions till all of the proponents have testified. So we will start with Sean Hill, Libertarian Party. Welcome back, Sean.
Thank you, Madam Chair. I didn't come prepared to give a second testimony, so I apologize for the lack of polish. In favor of RS 2357, I had only a couple of things to my oral testimony for the RS 2356 bill. Again, I stress that I compromise my free market libertarian principles in order to support this, but I feel the threat to individual rights is so great that we cannot rely on the goodwill of employers alone. We know that some of the largest employers in the Wichita area are going much further than making limited inquiries with the religious exemptions, and they aren't providing for conscientious objections. While I sympathize with small business owners, their employees can afford to fight this even less than they. As mentioned, this only becomes a problem for businesses who intend to deny these exemption requests. As a show of good faith and unity against such blatantly unethical and unconstitutional mandates, I ask them to drop their opposition to this bill and focus on a commitment to protecting the human rights of their employees. This country stands at a crossroads where we must choose between freedom and oppression. These business owners are citizens like the rest of us, and we call upon them to join us in our fight. Their support can help make the case to the federal government that this mandate is unworkable on practical grounds. I would like to respond to Senator Petty and Governor Kelly's comments about the Star of David by pointing out that many Israeli Jews are using the same symbols and language in the same context to resist their own vaccine passport system. They hold huge billboards with the Star of David and terms like Holocaust, apartheid, and graphics of arms with tattooed numbers. They protest by the tens of thousands in their streets. Those of us who draw these comparisons do so because we are familiar with the relevant history and the significance of such a statement. We refer to the precedent set in 1930s Germany, and you accuse us of comparing mandates to the gas chambers of the 1940s. They didn't get there overnight. They got there incrementally. Well over 1 million of Israel's 9 million people voluntarily choose second-class citizen status rather than take their now mandatory boosters, and they see it much the same as so many of us. Thank you again for calling this committee and hearing our testimonies.
Thank you. Next, we have Joanne Atchity, followed by Martin Tinker. Welcome back, Joanne.
Good afternoon, Madam Chair and committee members, and thank you once again for having us. I am Joanne Atchity from Shawnee, Kansas. I am very much in favor of accountability. At this writing, a member of my own family is in an ICU with a reaction to the COVID-19 so-called vaccine. He had been coerced by his employer. In order to maintain his employment, he was told he must be vaccinated by last Monday. He waited until the last possible moment, hoping that sanity would return into the world. So Monday afternoon, he got the shot. Within an hour, he developed a dangerous cardiac arrhythmia. His employer, for having required an experimental treatment, which is still only available under emergency use authorization, has no liability for the injury he is suffering. The manufacturer of the shot has no liability. Back in 1986, vaccine manufacturers went to Congress saying that vaccines are unavoidably unsafe. I will repeat that. Vaccine manufacturers admit and acknowledge that all vaccines are unavoidably unsafe, which was why they have been given protections from liability. In addition, the PrEP Act also affords liability protections for vaccines used under emergency use, which all of these still are. So who's left holding the bag? Again, to address the gold star conversation, it was said that we have not yet reached the point of human experimentation. But as I have just outlined, all of these vaccines remain experimental. The population of the world is undergoing the largest clinical trial in human history. So yes, we have very much passed the line of human experimentation. Vaccine reactions, called adverse events, are not rare. This is not a statistic for me. This is my family member. Please, I implore you, make sure that this coercion, which places all of the risk squarely on the person who's being required to get the shot or the treatment, must be absolutely prohibited and forbidden. We are counting on you to protect our innate, inalienable freedoms. Where there is risk, there must be choice. Thank you for your attention. I am sovereign.
Thank you. Next, we have Martin Tinker. Welcome back, Martin. Martin? Okay, he is the last proponent listed. So committee, questions for our proponents? Seeing none, we will move to opponent testimony. First, we have Eric Stafford, Kansas Chamber of Commerce. Welcome back, Eric.
Thank you, Madam Chair, committee members. Good to be back after short lunch. Here today in opposition to the second proposal that is focused on unemployment insurance benefits and eligibility specific to COVID and treatment of COVID and employment status for individuals who are refusing to be vaccinated. First point I'd like to make today, really, we've heard over the last year, 12 months ago, we were sitting here talking about fraud and the trust fund health and the integrity of the trust fund, where there are a lot of issues dealing with individuals not being able to get benefits who are rightly entitled to, hundreds of thousands of Kansans having claims filed under their names and Social Security numbers. The Modernization Committee this summer and fall has been doing a lot of work to address those issues, but the UI system was intended to focus on providing supplement to income, not replacing income, but supplementing income when individuals lose their job by no fault of their own during economic downturns. And we've had positions that we've taken in the past where people come in and ask for expansion of eligibility on the unemployment insurance system that erodes the integrity of that trust fund. And so along the same lines, we're here today with similar objections or concerns based on what's in this bill today. We have received comments from our members that they're concerned about this exacerbating the workforce shortage that we currently face, and that becoming an issue. The language throughout most of the bill focuses on if they're denied the request that they've made, religious or medical, that we've talked about earlier in the first bill. But there is some language on page 65 under the retroactive piece that includes some language that the individual voluntarily left employment without good cause or was discharged or suspended for misconduct. So if they're voluntarily leaving the job, retroactively, we will allow those individuals to be entitled to benefits. And this just goes back to our first point that I wanted to make about the integrity of the trust fund, of an individual choosing to leave their job on their own will. We are an at-will employment state, as you heard during testimony last month, several weeks ago, when we talked about our concerns with workforce shortages, and our fear is that this could result in individuals attempting to game the system, so to speak. I know there might be some legitimate cases out there for somebody who strongly objects, and we heard earlier about big employers in Wichita from a previous conferee. I don't want this to be big versus little or bad employer versus non-bad employer. They're doing what they can to comply. Some of the large employers in Wichita and Kansas City are under the federal contractor mandate, which is much more stringent. There is not the testing exemption that the OSHA rule has. They're obligated to require anybody on their presence to be vaccinated, and it's a tough but definitely way more strict mandate than what the OSHA one is. And so I'll stop there. I think you're about to hold up the orange sign that says stop. Appreciate the heads up on that and the opportunity to speak today. So, Madam Chair, thank you for the opportunity to be here, and I'll be happy to answer any questions.
Thank you. Next, we have Kelly Summers from the Kansas State Nurses Association. Okay, Dan Murray, National Federation of Independent Business. Welcome back, Dan.
Thank you, Madam Chair, members of the committee. Dan Murray, Kansas State Director for NFIB. In the interest of time, I'll just maybe defer to my written comments. You heard a lot of our comments this morning as it related to the other RS, and Mr. Stafford with the Chamber covered essentially our same argument. So I'll just stand for questions at the appropriate time.
Thank you.
Thank you.
And finally, committee, we have Rachel Monger from Leading Age Kansas. Rachel, welcome back.
Thank you so much, Madam Chair. And I'm not going to reiterate everything from before, but our concerns arise from the same source as the religious and medical exemptions. Our providers must comply with those federal requirements on granting exemptions and making accommodations for those exemptions. The exemption language from CMS is clear-ish. The language on what accommodations providers are allowed to make is less clear, and we have submitted a list of questions to CMS, and we're waiting to hear back. Either way, it seems evident that there is likely to be times that providers will have to deny exemptions or accommodations based on federal regulation, or they risk paying fines and losing their Medicaid and Medicare funding. We believe it is unfair to put an extra financial burden of paying these unemployment claims on our providers just for following federal regulations they have no control over and really have no choice but to comply with. So we are just asking you not to do that. Thank you so much, Madam Chair.
Okay, questions from committee. Representative Owens.
Thank you, Madam Chair. Question is for Mr. Stafford. And while he's walking up here, I just wanted to clarify, you referenced page 65 of the bill, and I wanted to finish that sentence as it related to grounds a claimant voluntarily left employment without good cause or was discharged or suspended for misconduct as a result of the claimant's refusal to comply with COVID-19 requirements after the individual requested an exemption or accommodation. So again, this entire unemployment requests or these payouts are tied to an employer refusing to accept religious or medical exemptions as prescribed by law. So then I will ask you the same question that I asked Dan Murray earlier. Do your employers plan on denying religious and medical exemptions that would then make this applicable?
Sure, Madam Chair. First of all, let me say I'm glad you asked me a question, because when I was up here earlier, I forgot to reference the SHRM testimony that they ran some scenarios. So I know they submitted some written testimony and wanted to be sure that we pointed you toward that on the potential impact of the trust fund based on various scenarios. So those give you some dollar amounts and the potential impact of the trust fund. So I'll start with that and then get to your question. So no, good question. I don't know. Again, I want to stress that each employer's circumstance is uniquely different, whether it's size or industry or their own personal philosophy, which again, reiterate, largely prior to the Biden administration, our employers were not mandating this on their employees. They were largely leaving it up to the individual's choice and consultation with their physician. So I don't know what they're going to do in terms of the religious exemption request. I know some of them are granting some of them are granting most of them, but again, each scenario is different. They're doing what they can to follow the current standards that are in place, both in federal and state law for religious exemptions. And so there's some concern over potential conflict there between the processes that could pass if they don't remain uniform based on what is in existence in current law today prior to all of this issue kind of coming forward. Yeah, I think overall, there's just pause if somebody voluntarily leaves an employer, that we're going to create a new exemption. And in conversation I know I've had with some of you guys as elected officials in the past, over the phone or in person, where, we're talking COVID, what type, because our fear is, well, what's next? What's the next scenario where we're going to create an exemption into our UI system? I don't know. Hypothetically, what we could come up with or fantasize about what is going to become the next scenario. We never thought we'd be here with this. I'm pretty sure everybody on the committee probably feels that way, of all parties. But this is where we are, and this is the policy decision that's being considered before us today. So we can only speak to what we know, not what we don't know. But I can tell you, again, to answer your question, our members are going to have a diverse response to how they're going to handle this. So I don't know if there's going to be any uniform approach to whether or not they'll uniformly grant those exemptions based on what you guys hypothetically might pass or try to work on in the future. It's just overall the concern about what would happen to what the impact to that trust fund would be. And as the previous conferee stated, something I didn't mention in our comments, I mean, whenever we talk unemployment insurance, I try to remind the committee and the public that employees pay zero into the UI trust fund. It is 100% funded by taxes on employers. So anything that opens up the potential eligibility to that will result in more usage of the trust fund, which results in more claims against the employers, which results in higher taxes when they pay those when they get their statements from Department of Labor at the beginning of the year. So that's the genesis of our concern. But we could try to start surveying, start asking to see what employers are going to do under these potential scenarios. But right now, I can just tell you that it's going to be probably a variety of responses based on each circumstance, because some might be under the OSHA, some might be under the federal contractor. Some businesses of 7 employees might be a subcontractor to the prime and therefore have to be 100% in compliance without exemptions, without weekly testing of all 7 of their employees. So to Dan's point, from the small business perspective, which we do, 50% of our businesses are small businesses. 50% of our members are under 100 employees. You could probably even increase that number if you're going to use 100 as your threshold. That'd probably be about 75% if we're going to say 50 employees or less. So by and large, our makeup, we have small businesses just as we have large employers too. So you can't sit there and separate, well, this is only going to impact the big guys or this is only going to impact the little guys. It's going to impact everybody through the various channels that the federal government's trying to go through.
Well, I don't want to rehash many of the same points I brought up in the past because they've already been heard. What I always want to remind the committee is where the problem really lies, and that's on the federal level. So we wouldn't be here without the federal government and these mandates. But I would also contend that the vast majority of the businesses in Kansas respect religion. They respect medical exemptions, and that by enacting the legislation that we are contemplating, it will provide them the opportunity to be able to continue to do so. And then those few that that would prefer to discriminate on religious grounds are then putting themselves in a position to have to pay the additional unemployment. So it's my contention that it's not going to be as drastic as what some would believe. But thank you very much, Eric. I really appreciate the dialogue.
Sure.
Representative Tarwater, did you have I thought I saw your hand up. No?
I didn't put my hand up, but I would like to follow up on those, his last statement, if that's okay.
Yes, go ahead, Representative Tarwater.
Thank you. So yes, Eric, thanks. You referenced Sherm's numbers, and I'm privy of a spreadsheet that was sent out, but I don't know, I don't see it anywhere in our documents. But it was referenced in your recent statement. Did we not receive that?
We did not. Can we get that?
Madam Chair, I believe that's part of the written testimony, so it wouldn't be part of the physical hard copies, but I could push out a link. There we go. Push out a link to the committee members if you like.
Okay, thank you.
Sure.
Thanks.
Sure.
We'll wait until everybody has those, and we can come back to that later. But I did want to reference, there was one thing that you talked about, and that was the retroactiveness of going back to September 9th. And, you and I, we worked very closely together this last session, and we worked really hard to get our unemployment trust fund soluble again. And we all know the big issues around that. If we're not soluble, and drastic changes in unemployment law would certainly affect the numbers. And I know what you're talking about. I've seen it. I'd like the rest of the committee to see it, because those numbers are pretty grave if you look at them in a certain way. Not only that, but as we progress, as the unemployment certainly will rise out of this mandate, once we reach 16 or 6%, we're then going to be at 26 weeks instead of 16 weeks, and that further perils the dollars. Further, then we lose our FUTA credits because we're not soluble. And so it's a snowball effect, which is why we hopefully gave the business community an out with the first bill, because if they just stick to that and accept these exemptions, we will protect the unemployment fund, and it will make a big difference. Would you agree? If we don't go over that 6%, and if we don't lay off 22% of our workforce, that will certainly drain the unemployment fund. Don't you think that would be a good idea?
Yes, with the exception that there's a lot of built-in assumptions that certain things have to happen in order to prevent getting there.
Well, you built the spreadsheet, and you made those assumptions, and you came up with a number of $5 billion.
I'm sorry?
$5 billion of losses.
No, what I'm saying, because you're getting to the point, well, if the employers utilize the exemptions that you guys are considering as a committee and as a legislature, assuming that, all I'm trying to say is that there are just a lot of assumptions that we don't know what the impact will be of the mandate on the workforce and whether or not Kansas businesses take advantage of that exemption created by the legislature. There's just a lot of assumptions that could potentially impact the workforce negatively, which would result in those higher numbers. Now, to your point, to the point that you're getting at, if they take advantage of the exemptions that you guys are considering, I would agree with you that yes, the impact likely wouldn't be that great. But we can't not stand up here and express concern about what negative outcome we could be facing if those things don't happen. So I do agree with you that the impact could be negligible, but there's a lot of things that have to happen in order to get there. And we can't live in a what-if scenario because we're dealing with so many unknowns.
Right.
If
the first bill passes and employers can no longer lay that 20% off, at least the ones that would fall into this category on the second bill that asked for an exemption, they were denied an exemption, and then they were fired. That's all this bill applies to. It doesn't apply to the whole 22%, but that's the number that you guys decided to put out. So if the first bill passes, this second bill really, it doesn't make an impact at all, because everybody keeps their job that would fall into this category. And as far as the backdating, I agree with you. And that's one of the changes I'm going to recommend is we can't be rewarding people for leaving a position for any reason. If they voluntarily leave, they leave. But if they ask for a medical exemption, they're denied, and then they're terminated, then certainly we need to find a way to help those individuals. And do you know how many people, if you look back to September 9th I do, 10.
I don't.
I called the Department of Labor this morning because I had the same concern you did. And so my concern backdating this and allowing for those 10 individuals that are in adjudication right now, it's not that big of a deal. But I get your concern on that one.
Yeah, well, and I think the concern, it is good to know that. I appreciate you reaching out to get that answer. The concern isn't necessarily that 10 right now. It's the 180,000 or 250,000. I can't remember based off that spreadsheet. I don't have it in front of me on my iPad, but what would the impact be for the masses based on the percentage when you break down the labor force on the vaccinated versus unvaccinated assumptions that were built into those models that was presented in that testimony?
Right. Okay. Thank you, Madam Chair.
Representative Carmichael, followed by Senator Petty.
Thank you, Madam Chair. I hope Mr. Stafford is still near at hand because I do have a question for him.
He almost made it to his seat, but he is back.
Helping me get my steps in, Representative.
Well, I'm just glad you didn't flee the chamber and out the door. Thank you for being here, Eric. I haven't seen the spreadsheet, and honestly, I haven't had a chance to read Sherm's testimony or even yours. I apologize for that. But I saw Alan Cobb, who I think is the CEO or the president of the state chamber. Is that right?
Correct.
Yeah, okay. I saw him on KWCH television night before last, and he was explaining that the chamber estimated the cost of this proposed bill, which is now in the form of a draft, to be in excess of $600 million. And Mr. Tarwater says it went as high as $5 billion. I only remembered $1.5 billion. But what, just before I get to the substance, what is the number or the range that the chamber believes this type of legislation will cost the Unemployment Trust Fund?
So as you get that, thank you, Representative and Madam Chair, as you get that copy of their testimony, the scenarios included in there from SHRM, Phil Hayes, if you recall, from Commerce Committee, is kind of, we're fortunate to have him both as a member of the chamber and of SHRM that we work closely with on unemployment insurance. Just went through various scenarios based on the percentage of vaccinated versus unvaccinated, based on the percentage of the workforce in the state, to craft various assumptions that show if the full 20 to 25% of the labor force that potentially is unvaccinated today were to just leave and not comply with the federal mandate, not be granted the exemptions that Representative Tarwater was referring to from the first bill this morning, kind of a worst case scenario. That's where you get into the big numbers. And then the testimony from SHRM has, I think, 4 or 5 scenarios that show, I don't want to say a sliding scale, but basically less of an impact. So, you might not be dealing with 20%, you might be dealing with 5%, or you might be dealing with a nominal number if there were to be an exemption in place that Kansas businesses were to utilize. So he put together kind of assumptions on what the potential impact of the trust fund could be. But yeah, there was that range, I think, from $500 or $600 million to Yeah, big numbers, $1.5 billion to $2 billion, I think, if I remember right.
Yeah, my recollection was $1.5 billion. My friend Chairman Tarwater seems to recall $5 billion. But let's just use the lower number, $600 million, and that's real money. I don't know much about the solubility or whether it's soluble at the unemployment compensation or unemployment insurance trust fund, but I am concerned about the solvency of the fund. In other words, how soon will it go broke? And if we gave it a $600 million unanticipated hit, I'm told that it would lose solvency perhaps next summer. Is that consistent that the fund would be bankrupt by next summer, even at a $600 million level? Or if I'm off, tell me how soon we go broke, even if it was just $600 million.
Yeah, thank you, Representative and Madam Chair. I think that's right. I heard some testimony from Mr. Brady from Department of Labor, who was asked a similar question. I believe that's roughly what his answer was. I don't know the trust fund balance off the top of my head. I was thinking we're in the $350 million range, ballparking. We did get the $250 million infusion from the legislation passed last year. There's another expected $250 million expected, or up to $250 million to be put into the trust fund based on the independent forensic audit of the trust fund that's going to be taking place from federal dollars. So you're looking at $500 million there. The unknown right now, employers have received their statements. The largest infusion of money coming into the trust fund always happens in the first quarter based on when employers pay their UI taxes. That's usually done by April 1st. They're, depending on the number of employees and the wages and all that, and the tax liability, there is some that carries over into the second or even maybe into the third quarter, but most UI taxes are reached by the first quarter, and that's when we get the largest infusion. But I think that's only looking, I think annually that's between $200 and $300 million roughly. So say you have an existing 350 and you get another 250, you're at 700, and then if there's some more benefits coming out, summer's not an unrealistic outlook especially under a worst case scenario or even middle of the road estimation or assumption.
So in short, we go broke as best we can determine sometime next summer.
Potentially. There's potential.
Thank you, Madam Chair. Thank you, Mr. Stafford.
Senator Petty, then Representative Tarwater.
Thank you, Madam Chair. I just wanted to, and maybe you mentioned this, but as I'm looking at the opponent testimony, and I didn't see it listed, but we have a piece here from the Americans for Prosperity. Is that correct? It's not listed, but we have it in our packet. Is that, so we do have written testimony of opposition from the Americans for Prosperity?
I believe.
Or is that new?
And was Elizabeth Patton going to join us via WebEx? No, okay. Yes, thank you, Senator Petty, for drawing attention to that. I do believe we have testimony from Americans for Prosperity.
In opposition, correct?
In opposition, correct. Yes, thank you. Representative Tarwater, then Senator Thompson.
Thanks, Madam Chair, and I apologize for asking another question regarding the spreadsheet, but I'd like to talk to Eric or even Sherm if they want to talk about the spreadsheet. So
I might take the easy road and just punt to Natalie. We'll see.
In this spreadsheet, and Phil is a good friend of ours, and he was very integral in writing the unemployment bill. We had a great team that put that bill together, and when he does a spreadsheet, the numbers are real. They're real, so I believe these numbers, and they're pretty drastic. But if you look at scenario 1, for example, he uses the total population of Kansas as to see what percentage is currently vaccinated. Well, half of that population doesn't qualify for vaccinations currently, or they didn't at least, because they were too young. And so the 53% number that he uses for that first scenario is not real. But that's what he was asked to do that, so he did that. And as you go through these various scenarios, there's not one on the page. Where's the scenario that scores this particular bill, that shows the number of people that will request a medical exemption or a religious exemption and be denied and be fired? Where is that on this page?
I thought there was one towards the end. Scenario 5, Natalie says.
Okay, well, scenario 5 is if both bills passes, and that means that employers must accept those, and the number is 0. I mean, those are our current expected unemployment numbers over the next several weeks, or 16 weeks, of 35,000 to 35 million to 45 million being paid out. Those are what we're expected to pay out absent any of this stuff. That's our current unemployment rate. And the reason that is there is because he's assuming the first bill passes so that this unemployment bill is really almost not needed, because employers will be required to accept those, and now employers have a way out. And so that number is ultimately 0, which is kind of why I requested this to be handed out. Because this morning you testified against a bill that gives us a way out of all of this. If this bill even doesn't pass, our unemployment rate will certainly jump above 6%, and we will certainly go to the 26 weeks. These are viewed on a case-by-case basis. You know that. We all know that. We know our Department of Labor gives people the benefit of the doubt. And when an employer is in distress or under pressure from the federal government to fire an individual for not getting a shot, and that individual loses his job, he's not going against his employment contract. He's not going against the employer. The employer had to fire him, so he will qualify for unemployment benefits. A lot of them will. Then these numbers become real. Then we become bankrupt. And to answer an earlier question, we have $657 million in the trust fund today, this morning. That's going to be gone under any of these scenarios. So I'd like to give you an opportunity to reverse your testimony from this morning, and maybe we could pass that first bill so we don't have to deal with any of this.
And that's, again, based on what are currently unknown assumptions on the position that our employer members would be put in, or not even just our members, Kansas businesses would be put in, with the uncertainty between the conflict of federal law and state law. And where do we fall? What's going to happen with OSHA? What's going to happen if employers start granting these that have federal contracts that don't allow any exemptions? Do they then lose those federal contracts? What is the potential impact between the two conflicting laws that Kansas businesses are trying to follow and decide, do we want to take the state law protection, or do we, and potentially face $15,000 starting fines per employee per violation from OSHA, or that's what we were saying earlier, and I think Mr. Murray said the same thing. We're stuck in between two
Madam Chair,
options.
I keep hearing that we're conflicting laws here, and the way I read our bill is we're just asking them to enforce the current EEOC guidelines, which are accept these medical and these religious exemptions. I don't see a confliction there at all. There is no confliction. We're just demanding that everybody get a fair shake, and they get their, if they have a religious exemption, they get it. It's allowable under the federal law. It's allowable under state law. Some employers just aren't following it. That's all we're asking. We're giving them a route out. We're giving the employees a route out. I don't see any conflict here. But I think we can all agree that if we don't do something and all these people get fired, a lot of them, most of them, will end up qualifying one way or another for unemployment because it's not the employer's fault. It's not the employee's fault, but they had to get fired. They lost their job by not for something they did or didn't do. So we need to protect this. I can agree with you. I mean, we talked about this for hundreds of hours last year. So that's my only point is I keep hearing this conflict in law, and I'm just not seeing it. It's not there. Maybe it'll be there eventually. Maybe the federal law will change, and when it does, we can't supersede it. We all know that. This is the one thing we can do, and that's what we're trying to do.
Pre-Biden mandate, take that out of the picture. It doesn't exist. If the employer had required vaccination prior to the Biden mandate and an employee failed, they would not be entitled to benefit. That was a condition of employment for the individual, which, again, reiterating that most Kansas businesses, by and large, were not. So it really was a non-issue in Kansas, and I think everywhere, because businesses, again, were largely leaving this up to the individual. They largely feel that it's not our place to ask, so they would not be eligible for benefits prior to the federal mandate. So I understand the way you're asking that question.
I agree with you. I mean, that's my point exactly. Yeah. But the federal mandate is here, and these people will be fired. Period. The 97% of your employers that don't have their own, those employees are going to have to be fired unless we can get them to accept a medical or a religious exemption. And if they're still fired, these numbers are real. And so we're on the same page here.
Yeah, well,
we're talking in circles at this point, Madam Chair. I appreciate you.
I understand.
And I appreciate your engagement, Eric. I really, hopefully, we can all get together and have some sort of resolve for this.
Senator Thompson, then Representative Owens.
Thank you. I'll beat up on Dan just a little bit and give you a break.
Thank you,
here,
sir.
Eric. Dan, Mr.
Madam Chair, and I apologize for stepping up, but I wanted to present or maybe give a possible solution that we could consider, but I'll take the question first.
If you would, please, Senator Thompson.
Thank you, Madam Chair. Thank you, Dan. Let me ask this question a different way. We heard from Dr. Brian Ardis on October 30th that the vaccines that we're using right now, one of the side effects from the FDA is myocarditis. And if you get myocarditis or one of these other things, you have a 20% mortality rate in the short term, and then a 50% mortality rate within 5 years. Given the fact that some employer may say we don't pass these bills, we sit on our hands, we do nothing, and you have 20% mortality rate of the employees who get this vaccine, or a fairly high number, have you guys calculated the possible risk to businesses for wrongful death suits, for increase in medical costs, for loss of employees' time at work, the number of people who may be out sick permanently, disability, all of those things? Have you done those calculations?
Senator, the short answer is NFIB has not, and I have not. I can't speak for the Kansas Chamber or SHRM as well.
So it potentially, considering the VAERS data, which we know only captures about 1% of the adverse reactions from a vaccine, as of yesterday, there was 18,078 deaths from the vaccine. let's go the full scenario, as long as we're going all the way out there, like some of these SHRM scenarios, that would mean 1.8 million potential deaths from the vaccine. That's a lot of folks. There's been 8,400 heart attacks, 818,000 adverse reactions reported, and that's only 1%. So isn't it fair to say that businesses should be looking at this and not just worrying about whether or not some employee decides to quit? There are actual valid concerns that we've heard time and time again this morning, and also on October 29th and October 30th. I think we're looking at this incorrectly. We're looking at the safety and liberty of Kansans who want to keep their jobs. They want to continue to work, and I guess my hope is that the businesses do that rough calculation in their head. And I know there's a lot of variables to the SHRM data. There's also a lot of variables here that may be equally as costly, if not more, and cause just an equal amount of loss in the UI trust fund if we don't do something. Wouldn't you agree?
Well, Senator, I can't speak to I haven't seen those numbers, so I don't know the validity or merit of those numbers. They may be correct, may not. I don't know. And then I certainly couldn't calculate the impact on the economy or the workforce. But what I would say is that the decision that is imposed upon businesses or small business owners, employers in Kansas was not made by us. It was made by the federal administration. When I was listening to Representative Tarwater and Mr. Stafford kind of communicate about the impact on the fund, what it might be, whether it's $6 or $600 million, we're not sure. I think I trust SHRM and Phil and some of their projections, and certainly it could be half of that, maybe more than that. We're not quite sure, but what I would say is, as a suggestion, as an amendment on the fly, as they're sitting there, maybe we consider using state general fund dollars to cover the amount that we do incur if we're able to track the actual claims that are made based on the provision of this bill, and we hold the businesses harmless for the mandates that were handed down by the federal government, not imposed by the employers themselves. Chew the fat. Thank you very much.
Okay. Thank you. Thank you, Madam Chair.
Representative Owens, then Senator Petty.
Thank you, Madam Chair. I think sometimes we just need to call a spade a spade. And this is about the most misleading document I've ever seen. And the organizations that perpetuated this $5.6 billion myth, it's very disappointing. And here's why. Here's why. Read the fine print on the very bottom. Might I point everybody to that? Let's read this fine print. If 22-356 passes in conjunction with 23-357, the Kansas UI Trust Fund solvency becomes a non-issue, as Kansas employers will have a straightforward legal backstop to run their businesses that balances safe and healthy practices with mask, weekly testing, whatever accommodations, as they have demonstrated throughout the pandemic. Furthermore, if both bills pass, employers will still have the ability to enforce other traditional performance management issues as it relates to continued employment. That's all. Thank you.
Senator Petty.
Thank you, Madam Chair. And I'll ask Eric to answer this question because the comment was made earlier, I think by Representative Tarwater, that these numbers of percentages of vaccinated would include children, but I don't believe that's correct. I don't believe children, there's no percentage of children vaccinated as of yet that is being circulated.
No, Senator and Madam Chair, I think what he was saying is that you're looking at the numbers of the population as a whole, and then you go into the the labor force. I don't think that. I won't speak for Representative Tarwater. I don't think that that's what he was implying.
I thought I heard vaccinated, and I wanted to just clarify. To my understanding, no percentages have been released yet as of children being vaccinated, so that the number vaccinated would not include children. but the population I understand.
I don't think in the scenarios of the civilian labor force, it would not, unless you're talking the 16 to 18-year-old entry-level population.
And they are already in that category. So thank you.
Any other questions? Seeing none, I want to thank all of the conferees for being here this morning and this afternoon and for your testimony and your answering of questions. It's been very helpful. Committee, now we're going to move into discussion and recommendations. I will open the floor, Senator Masterson.
Thank you, Madam Chair. Thank you for all the conferees that attended. I would like to start I have a few, well, I'll just start with one. I know I had a suggestion for some language adjustments around, and it was just to simplify, and I think Jason has it, who can sign the medical exemption. There were some questions around the physician, and actually one of the testimonies today talked about chiropractic. I think this would cover that because it's a broader, what I had him do was use the language from the current statutes as they pertain to child vaccinations and medical exemptions, so it just broadens that. It matches that. I didn't want to get into the, for those that work under the dome, the APRN, physician, scope of practice. I didn't want to bring anything unnecessary into the discussion, keep it clean. So just simply, they should come out. But I would propose that we match that language.
I'm sorry to interrupt. Are we going to bifurcate this discussion? We're doing 2356 first and then 20?
That's an excellent question. Yes. Yes, thank you. Thank you, Representative. Yes, we are going to be looking at 2356.
Thank you, Madam Chair, and Representative Miller for
Yes,
clarifying
thank you.
that. And if you need Jason to explain, that would be, unless anybody's got any questions.
Does Representative Carmichael have access to this? Okay.
Madam Chair, I may not have it immediately. I appreciate you looking out for me, but please proceed. I understand where the President of the Senate is going.
Thank you, Representative.
And in fact, I have it now from the reviser. Thank you.
Representative Landwehr.
So, Senator Masterson, then the new language of or another person who performs acts pursuant to practice agreements, protocols, or at the order, direction, or delegation of a physician. This limits who?
Madam Chair, I'm not sure. I mean, yeah, this is just, it's identical to the language in the current statute as it pertains to medical exemption for students, I believe. And so that's basically anyone that's physician directed, which could include an APRN and a chiropractic. It's to match the language and avoid any unnecessary discussion.
So just current law?
Which is current law.
Just quick point of clarification. Where can is there a place where we can find that list? I don't know whether one of the advisors knows that or not, Madam Chair.
Jason or Scott, do you know? Scott.
Thank you, Madam Chair. Senator, I'm not sure if there is a list somewhere that is put in these terms. I'd have to look more into that. It would be a matter of each category of provider, their licensure scheme under Kansas statutes, and whether their practice is kind of defined in terms of taking delegation. Off the top of my head, it would include a number of level of nurses, so nurses up to advanced practice registered nurses, physician assistants. And there are probably some others that are a little less directly related but still have that
If I
relationship.
may, Madam Chair, just a quick follow-up for Scott. Would like a homeopathic doctor be included in that? Are they under the State Board of Healing Arts?
Madam Chair, Senator, so I think this definition doesn't speak in terms of the State Board of Healing Arts.
Oh, okay.
So this doesn't include necessarily everybody who is licensed or regulated by the State Board of Healing Arts. It's people who have this working relationship by law with a physician licensed by the State Board of Healing Arts. So nurses, APRNs, all of them are handled by the Board of Nursing, but they have relationships with doctors by law in the scope of their practice.
Okay. Okay, that clarifies that. Thank you. Thank you, Madam Chair.
Senator Warren.
Thank you, Madam Chair. This definition, I'm sorry, did I miss the statute that it's in currently that we're kind of mirroring the language from?
Yeah. Madam Chair, Senator, I don't have the citation off the top of my head, but we will look into that for you.
Thanks.
Thank you. Senator Warren.
Just one other follow-up. We heard testimony earlier this morning, and maybe this afternoon, I think it was earlier this morning, that you're a healthy individual, you don't meet the medical exemption requirements in the RS number, and maybe you don't have a sincerely held religious belief, and currently RS 2356, as it's written, you wouldn't have just sort of a conscientious objection opportunity to not have to get vaccinated. Yes. Oops, sorry. That's my question. Thank you.
Okay, we are sticking to the language at hand. Any more comments on the proposed language from Senator Masterson? Senator Masterson?
Thank you, Madam Chair. I mean, just, to this, it accomplished two things in my mind. It eliminated any kind of disconnect or fight from under current statutes and broadened the number of individuals that could sign medical exemptions. We can talk about some of the further, but I would comment that I think there was some of the conferee comments this morning. I think they're misreading kind of the term of art of religious exemption, right? That it doesn't have to be a formally organized denomination or church, right? That's a sincerely held belief. And I think the current version of how we read that is practically synonymous with conscientious objection. And we have a stronger legal position in court because that term has been used. But so this is simply, though, to make that broader number of individuals that could sign those medical exemptions. And I think the intention would be to actually make, this is a motion, if you will, for the committee to recommend this adjustment to the language. It is not, we're not amendments and bills, but I would like the committee to recommend this as the language in that portion.
Okay, we have a recommendation by Senator Masterson, a second by Representative Owens. Any further discussion? All those in favor say aye. Opposed, no. Motion carries. Representative Owens.
Thank you, Madam Chairwoman. Earlier, we spoke about my concern for punitive actions from companies or organizations that see fit to accept a religious exemption or a medical exemption, but then somehow are punitive in nature towards that employee. If the revisers would distribute that amendment, I would appreciate it. Thank you. While that's being distributed, I will just determine, and I know the revisers are going to be looking up this statute as well, but punitive action is actually taken from another statute that's currently within Kansas Code. And punitive action means any dismissal, demotion, transfer, reassignment, suspension, reprimand, warning of possible dismissal, or withholding of work. Again, the basis behind this recommended change to this is to ensure that In the event that a religious or medical exemption is submitted and thereby exempted, there will not be any retaliation by the employer for the employee.
We have a motion by Representative Owens to accept this recommended language and a second by Senator Masterson. Any discussion? Senator Petty.
Thank you. This is a question for Representative Owens. So I'm just looking at the first, where without punitive actions. So does putting without punitive action where you have it, does that then mean that, I'm not sure where the punitive action comes in. Does it mean that the employer can't have any punitive action, or does that supersede anything else that follows? For example, any requests for any waivers?
The intent when discussing with the revisers on the way that this was written was that the employer shall exempt the employee from such requirement, again, assuming the medical and religious exemption, without punitive action. So this is punitive action towards the employee for submitting those exemptions.
I'll just follow up because I didn't quite understand. So it's exempting the employee from any punitive actions for submitting or not submitting or not having to, there's no submitting, which is it?
Let me just read this, and maybe this will help clarify, because I had to read it myself. Notwithstanding any provision of law to the contrary, if an employer implements a COVID-19 vaccine requirement, the employer shall exempt an employee from such requirement without punitive action if the employee submits a written waiver of request to the employer stating that complying with such requirement would, again, medical exemption, religious exemption. So if they submit it and comply with the rest of the statute, they cannot be retaliated against for doing so.
By the employer?
By the employer, that is correct.
Thank you.
Any further discussion? Senator Warren.
Thank you, Madam Chair. This is more a question for the reviser regarding the language for the definition of punitive action. We have in, for instance, employment discrimination law, the definition of an adverse, I'm trying to think of the right term of art, if you will, an adverse action or something that would encompass, I believe, what's attempted here. Do we, to mirror what's already in law, that's already in common law usage, because punitive action, I think what the purpose of the amendment is to get at that you're not then having to, like we heard testimony from today, you're not having to only eat in a area of the business where you're separated from your other employees, or you're separated in your workspace from other employees, if that's the intent. I think it would be important, or maybe not, but important to parallel how we look at discrimination in employment practices already, if this is going to be, subject to legal challenge and things like that. So I'm just wondering if we have language at hand that might be something to look at as we're determining what definition of punitive action might be.
Jason.
Madam Chair and Senator, I took this one deliberately from a slightly different act. I took this from the Kansas Whistleblower Act, which is a little broader. It's KSA 75-2973, if you wanted to look at it. And the term defined over there is disciplinary action. So we went with punitive here instead, but used the same definition. And the thinking was it's broad enough to kind of cover most adverse employment actions in sort of a more broad way. But that's the thinking, is that we use the Whistleblower Act definition.
Okay, well, that would have been helpful to know before my question, but we were thinking along the same lines, but I didn't know you were thinking along those lines, so that would have been helpful to know, and maybe I missed that in the explanation of the amendment. So we're mirroring some known language already in statute, and that's in common practice and is known interpretations, and so we're not suggesting something entirely new here. Okay, great, thank you.
Any further discussion? Seeing none, we have a motion and a second. All in favor, say aye. Aye. Opposed, no. Motion carries. Senator Thompson.
Thank you, Madam Chair. I have a proposed amendment, but I haven't seen the language yet. I'm wondering if Mr. Thompson has it ready with regard to the vendors and contractors who are tangentially working with other companies. I don't know if it hasn't been sent to me yet.
Madam Chair, I have one nearly ready that just adds independent contractors, and we could do that conceptually if you'd like. I don't have anything broader than that at this point.
Okay, let's proceed with that. Oh, Senator Masterson.
Thank you, Madam Chair, and I would certainly agree with the conceptual amendment of adding independent contractor and would second the motion. Because I think in the earlier discussion, we saw that subcontractor, vendor, those all are employers in and of themselves and are covered by the Act. The one thing that seemed a little squishy might be that single independent contractor, so I would second the motion to add independent contractor in the vein in which Jason suggests it to clarify that.
Yes, Jason.
Thank you, Madam Chair. Just to clarify for the committee, I know you can't see it, but essentially all I asked for the balloon to do was put or independent contractor next to employee in a bunch of places in the statute. So that's why it's taken a little time, but it just adds or independent contractor wherever we say employee, just to make clear that it covers both.
Okay. And Madam Chair, if I might, I'll formally make the motion that we do that conceptually, and I think I've got my second.
And seconded by Senator Masterson. Discussion. Representative Carmichael.
Thank you, Madam Chair. I do have a question for the maker of the motion, the distinguished senator. Oftentimes, independent contractors are individuals or sole proprietorships. For example, at the aircraft plants, they sometimes hire an individual on an independent contractor basis to do a particular task. And without getting into the distinctions between employees and independent contractors, you have just a one-person independent contractor. Those self-employed individuals are usually not covered by unemployment at all. We don't pay in, and we're not eligible for unemployment because it's our company, we're the boss, we are the independent contractor. Is the intent here, though, to also protect those independent contractors in the same fashion with respect to unemployment benefits as direct employees of an employer?
Sorry about that, Madam Chair, if I may. Representative, we're not talking about the unemployment here. We're just talking about the requirement for receiving the vaccine and their ability to opt out via the bill and the religious or medical exemptions.
And so if an independent contractor is terminated because they because they refuse, perhaps with medical exemption, religious exemption, or otherwise, if they refuse the vaccine and they're fired, they're not going to get any unemployment because we're not protecting independent contractors?
Well, yes, that would be correct. But through the bill, I do believe, and I'm not sure, I may defer to the reviser on this before I speak incorrectly. I I'm assuming, well, maybe I shouldn't make that assumption. Let me ask the revisor, would they have any civil action against that group that they're contracting with?
Madam Chair and Senator, under this section, you do provide a civil action. So under this section, by putting them in here, they would have an action against the employer just like the employee would.
Okay. Does that answer your question, Representative?
You know, as a matter of fact, I think that leads me to where I was ultimately going with this, and that is I agree with the revisor's interpretation that while, and I don't know if the revisor said this, but I'll say this, while those individual independent contractors may not be able to collect unemployment because they're not eligible in the first place for unemployment, they would be able to sue, you don't want to say their employer, but at any rate, they're able to sue the company that's paying them and recover their actual damages, i.e. wages for being off work and perhaps other things, and they get to collect their attorney's fees. So this indeed may well be a boon to independent contractors who don't want to have to go to work. So thank you, Madam Chair.
Senator Warren.
Thank you, Madam Chair. I understand that this amendment clears up some of the questions I had earlier asking the revisor, and well, you know, are we including independent contractors here or are we not? It does bring to mind a scenario. You have an independent contractor who is not vaccinated and then applies for work and bids for it and things like that, and then is not hired for the job. Would they then have a cause of action under this bill? I guess maybe that's a question for the revisor.
Senator, can you repeat that for the revisor?
Sure. The question is, if you're an independent contractor and you haven't been vaccinated and you apply for work from a potential employer, and then you are refused the job, then do you have a cause of action under this bill?
Thank you, Madam Chair. And Senator, that I understand there's a little nuance to that. I'm glad I had you repeat it. So the only time we're worried about an applicant for employment is when it's an employee. So under the bill as drafted, we're worried about applicants who are going to be employees, but we're not covering applicants who will just be independent contractors. So it would have to be an existing independent contractor, I think.
So then I'm concerned about the conceptual amendment, because when I heard the conceptual amendment, I had thought we were amending it every time it says employee. We were also putting employee or independent contractor. So I would need to see the specific language written before I could want to pass the motion or not, would be my suggestion, unless I'm understanding what the conceptual amendment is.
Senator Masterson.
Thank you, Madam Chair, and I think there may be some misunderstanding. So having been an employee and been an independent contractor, there's no obligation of a company to hire any independent contractor for any reason whatsoever. You're not obligated. This would go to the independent contractor. And again, narrowly in the bill, it would have to be an existing independent contractor that they told must have a vaccine, that filed for a religious exemption under his contract and was denied, and then the contract let go. It would have to be seriously that thin. But there's no mandate for any reason that an employer have to hire a particular contractor. So it wouldn't apply to that.
Senator Warren.
Thank you, Madam Chair. And with all due respect and understanding the amendment, that may be, but if what this bill says is, I would just like to see it written before we would vote on the motion, would be helpful, because this is a brand new section of law, and you don't have an obligation to hire an independent contractor. we're an at-will state and all that. But I just want to make sure that we're being clear. And so I would want to see it written before the motion is voted on, would be my request.
Jason, do we have an ETA on that? No pressure.
No, I don't want to misspeak, so I'll get it up here as soon as I can.
Okay, so we will come back to that, awaiting that language. Any other discussion on 2356? Senator Thompson.
Thank you, Madam Chair. And this came up as a course of a lot of the discussion. I think there was some testimony on this. The concern that with regard to the medical exemption portion of this, that the Medical Licensing Board has threatened doctors with their loss of license or punitive action for not signing medical exemptions. Or in other words, there's going to be a lot of medical doctors who are reticent to do so, which closes the door on using that medical exemption to a lot of people. And I don't know, we haven't had a significant discussion on this, but there are people who have pre-existing conditions that would make it so it's really dangerous for them to take a vaccine. And is there anything we can build into this bill that would help these doctors who, and I've been talking with numerous doctors who have been quite frankly frightened. We saw Dr. Michelle Hand testified on the 30th. She said outright, she said, I may lose my job for testifying here. Is there anything we can do in this bill to protect those doctors who somebody comes and they have a blood clotting disorder or some other disorder that they know makes them at risk for getting this vaccine, that we can protect these doctors? It's just a general question for the committee. And if anybody wants to answer it, I'd appreciate it.
Senator Masterson.
Thank you, Madam Chair, and why I actually appreciate and relate or understand the issue. The narrowness of this bill, just dealing with the exemptions, I think would broaden the scope of that bill wide enough. We would risk potential failure of the whole thing at this point. I'm not saying this isn't something that shouldn't be taken up in regular session. It's a matter of course. Because I know where we're headed, but I think in this context, it could potentially spread this out too far and put us at risk.
Representative Miller.
If I may follow up with the senator's point, since the primary purpose of this proposal is to punch a big hole in the federal requirement, I'm not sure why we're even requiring a doctor's statement. Why don't we just make it like the religious exemption we've written here that just says you sign a statement saying you're entitled to a medical exemption and you believe that taking the vaccine would seriously jeopardize your health, you make a statement. Who says we have to have a doctor sign off on this? We're mostly doing this just to punch a hole in the federal mandate, and the federal mandate has given us the opportunity to punch a hole by saying that religious and medical exemptions are okay. So why don't we just make the medical exemption every bit as broad as we've made the religious exemption?
Representative Owens.
I'd be happy to take a shot at answering that, and that all comes back to the way the EEOC handles things, because on the federal level, they do require that signed statement by the doctor, which is different than the sincerely held religious belief that does not. So in both instances, we're attempting to mirror federal law. Thank you.
You're the lawyer, not me, so I'll accept your.
Well, I have served on judiciary for about 3 years now, so I'm kind of a quasi-lawyer some days. Thanks.
Okay, we are going to take a 5-minute recess. We will come back at 3:10. Okay, we're going to come back from our 5/15-minute recess. Senator Thompson.
Thank you, Madam Chair. Given we've had some discussions about our motion on a recommendation for the vendors, and there's some concerns legally that I think we need to go into greater depth on, so I'm going to withdraw my motion at this time.
Okay, that motion is withdrawn. We are now, committee, going to turn our attention to RS 2357. And I will open up discussion for 2357. Representative Miller.
Thank you, Madam Chair, and thank you for the break. As I stated earlier, I do have a suggested amendment. If we can pass around the hard copy, and just to be on the safe side, I'd prefer Jason explain it before I comment. I've got mine.
All right. Thank you, Madam Chair. Hopefully you all have a copy. And this was sent out a little bit ago and hopefully posted at Representative Miller's request. So I've included page 31 just so you see the beginning of the statute, 44705. I didn't want to leave off the beginning of that, and 32. But the first change is on page 33. So as I said earlier, we're removing the requirement that the individual request an exemption or accommodation and have that denied. So in this case, it would say that because the claimant has declined to accept work that requires compliance with a COVID-19 vaccine requirement as a condition of employment, because the individual would refuse to comply with such requirements. So not that they asked for an exemption and were denied, but because they would refuse to comply, that's all that would be required. And then page 37, that's to give you the beginning of the next section, and it goes on for a few pages. Because this statute is very long, I apologize. So you get to page 49, and that's the amendment at the bottom of that subsection. So you get the individual would refuse to comply with such requirement. Again, same language as before. And then on page 65, you get the strike of after the individual requests an exemption or accommodation. And you get the same strike on page 66. Again, removing that requirement that they apply. And I apologize, I don't know why these didn't print in the copy, but there were 2 other places that we had strikes just like that, and I don't know why they didn't show up. They were the same, and I can even tell you what page they were on. Let me double check that. Madam Chair, there's one on the bottom of page 41, which somehow didn't end up in the draft. I don't know if these just got printed, not double-sided, and that's the problem, or some of them did and some of them didn't. So it's in the PDF that's posted. So it's there on the bottom of page 41. We strike that after the individual requested clause. And then at the bottom of page, or the top, I'm sorry, of page 48 is the other one. So somehow those just didn't get made in the physical copy that we have here in the room, but they're in the PDF online.
Representative Miller.
Thank you, Madam Chair. And if I may, just a couple minutes to explain where I'm coming from so that people don't try to read too much into questions I ask. I want to make it clear generally what my position is on this subject. For one thing, I support vaccinations. I encourage everyone who can to get one. I agree with the President that the current vaccines are safe and effective. I might make it clear that I'm quoting President Trump when he said that this year on September 1st. I agree with Governor Kelly in that I don't believe the best way to approach the issue of getting everyone vaccinated, that the approach should be the one dictated by the federal government. I don't believe, as some of the emails and some of the testimony has indicated, that there's some evil purpose behind President Biden's mandates. I believe he genuinely believes that vaccinations are a way to get us out of the COVID-19 epidemic. I just don't happen to agree with the approach that he's using, as Governor Kelly has said. I would also remind people that the mandates early on in this pandemic that Governor Kelly did impose were consistent with what the federal government was telling the states to do when we had a lot less information and data and research about the whole virus. I read in the Kansas City Star the president's comment, and so we don't get our presidents confused. This time I'm talking about President Masterson, and I understand that quotations don't necessarily end up in print the way they came out of our mouths, so I want to read what he was quoted as saying and not necessarily hold him to that language, but my point will be the same. The quote is, the bill, speaking of this one, would ensure that those fired for refusing to get a COVID-19 vaccine can receive unemployment benefits. I agree with that statement. However, it doesn't accurately describe the draft that we currently have in front of us, because the only people who can draw unemployment under this draft are those exercising a medical or religious exemption. I happen to believe that anyone who is coerced or actually fired, coerced into quitting or fired because of their objection to a forced vaccine should qualify for unemployment compensation. As a lawyer, by passing the bill in its current form, we are putting some very low-hanging fruit out there for a little organization we may be familiar with, known as the American Civil Liberties Union, who seems to have a pretty good track record in terms of success against the state, as well as recovering, at this point, millions of dollars in attorney's fees for our improper position. The reason I say that is a little thing called the Equal Protection Clause of the 14th Amendment, which in essence reads that, nor shall any state deny to any person equal protection of the laws. And the drafting of this amendment as it currently exists basically says if you have a sincerely held religious belief, you then may qualify for unemployment compensation. The Freedom of Religion Clause in the U.S. Constitution protects not only those who have a religion, but those who do not. This amendment sets up two classes of individuals: those who have a religion that the underlying tenet is against vaccinations and intrusions into the body, versus those that don't. And I appreciated the testimony from the young man this morning who was using the term conscientious objector. And frankly, if you have a frank discussion with those who say they have a religious belief against vaccinations, you'll find it's really not based on their religion at all. It's based on a personal objection for one reason or the other to accepting this particular vaccine into their body. Very few religions actually have as part of their religious doctrine opposition to vaccines. In fact, I'll use my own religion as a good example, which is fairly mainstream religion, Roman Catholicism. The pontiff himself has signed off on COVID-19 vaccines. So it's very difficult for a Roman Catholic to conscientiously say, I have a religious objection to having the vaccination. But even though I personally have come to the conclusion that the benefits of getting vaccinated far outweigh the risk. I fully respect those people who do not agree with me. I respect the fact that many people, some on this committee have expounded on it, believe that the race to vaccines was too quick, that the necessary research is not concluded about the after effects. So I don't believe that when you, as an employee, are being required to have a vaccination, that that is not a good cause for departing your work. And I differ a little bit to what was said by one of the representatives earlier today when he referred to unemployment compensation as a reward. It's not a reward. You don't make the same amount of money when you're unemployed as you do when you're employed. And most people I know that are unemployed don't choose to be that way voluntarily. Most people in this country have a work ethic, and they are much better served themselves to be productively and fruitfully working, not to be out of work. It's unemployment compensation. It's to compensate you, and it doesn't compensate you fully, again, but to compensate you for being out of work. Again, I don't agree with the federal mandates. I happen to agree that we should be in court. I happen to believe it won't be too much longer. The decisions will be issued where those mandates are unenforceable. So I don't get caught up in the despair of billions of dollars affecting our unemployment trust fund. In the meantime, those people who have already left employment because of the onerous mandates, I think should not be punished. And I do believe that it is, along with a number of already listed reasons for voluntarily quitting and still receiving unemployment compensation, this one should be added, and it should not be confined to the two that we have limited in this bill, lest we risk that very legislation being struck by a federal court as violative of the 14th Amendment. That's the purpose of my amendment. And very simply, what my amendment does, even though there's a number of places it's addressed, it just says, if you are forced to quit or you are in fact fired as a consequence of your refusal to accept the vaccination, you will be entitled, upon a proper application, to unemployment. You will not be disqualified from receiving that if the jobs you apply for require you to be vaccinated. That will not be a reason to prevent you from continuing with that payment. I appreciate the time. Thank you, Madam Chair.
Do you have a motion, Representative?
My motion is that the balloon amendment be included in our recommendation to the special session.
We have a motion. We have a second by Representative Landwehr. Further discussion? Senator Masterson.
Thank you, Madam Chairman. And this seems a little counterintuitive, but I think what we're looking at here is, and I have a lot of respect for the representative because I think he's one of the most clever individuals in the building. And he can appear to be doing one thing while doing another. And I think what we're potentially looking at here is basically a torpedoing. And not that I don't agree with the underlying sentiment, but this is very narrow. But what we'd be setting up here is bringing those SHRM estimates to real life, for number one, right? We wouldn't be able to even know whether the real loss of employment was due to that belief or due to some other action. And I'm claiming that. It's that very mechanism that meets those guidelines, the EEOC, as much as I don't like that. It's that which allows the coexistence of the disaster, which is the Biden administration and what it's doing, and our businesses to give religious accommodation to their employees. I think if you take this scenario, you run the risk of setting up exactly what we've been trying to thread this needle and avoid, which is that conflict. And so while I actually agree with the underlying sentiment and would like to take those steps, honestly, I'd like to join the representative and take those steps in regular session. I think this current action potentially puts at risk our ability to get all 111 cars across the finish line and actually protect people that may lose their jobs now. And so I'm not trying to disparage anything, but I think this potentially runs the risk by making it so broad and the margins are so thin when it comes to the politics of it, right? There's the policy and the practicality of it, and then there's the political aspects of it. And we must get these cars across the line in order to truly protect individuals that need that between now and then. I think in the end, we win in court. We're going to see that happen. We're going to win in court. And if we do this soon, I think we put that almost entirely at risk and potentially fail to get the votes to override a veto or get this thing across the sun. That's I'm not saying that I am the purveyor of all truth. I just believe that to be the case. And so this is this weird conundrum where I actually agree with what we're trying to do, but I think the timing could cause us some real grief. And so I would actually oppose the amendment.
Representative Tarwater.
Thank you, Madam Chair. A couple of things. First, I think it would be a great idea to be able to do this. However, those numbers that are on that Sherm Street sheet, they are real numbers, and they don't do justice to what this amendment would do. This amendment would be the end of our unemployment trust fund. It would cause our employers to lose their FUTA credits, and we would have to raise the rates on our unemployment so high that they would pay more in unemployment tax than they do in income tax. It's just not a feasible option. Secondly, the federal government gets involved. They watch unemployment law very closely. And anytime we make a change at the state level, they review it. And if it's not up to par, if it's not something that is acceptable by federal law or rules, they come back to us and they tell us that it's illegal. In no case can we pay unemployment to an individual who has voluntarily left their job for any reason. And so it's an illegal motion. That's just my opinion. But in no case can we pay unemployment knowingly to somebody that left their position on their own. Thank you.
Senator Warren, then Representative Miller.
Thank you, Madam Chair. I just want to echo the sentiments of Senate President Masterson and Representative Tarwater that, while we might agree with the sentiment and the, initial thought behind what it intends to do, we have to be measured in our response and do what we know can be effective. And we have to fight those kind of fights and win on those rather than something that wouldn't work. It would bankrupt the unemployment fund and would not be a proper exercise of a change in the law, because you can't be compensated for unemployment if you just leave your job for no reason. And that's what the amendment, though I understand the intent, that is the effect. And we have to, as the legislature, look at the practical consequences, and that would be the effect. And it's an effect that won't work for Kansas. So I would also stand in opposition to the amendment as it's written. Thank you.
Representative Miller, then Representative Carmichael.
Thank you, Madam Chair, and I do appreciate the President's compliment that he believes I'm smarter than I look. That's how I took him to say. And again, this amendment has just been sprung on you, so if you misunderstand it, I understand. But if you look carefully, it does not in any way say you can quit for any reason. It specifically says that the reason has to be that you left your job due to the fact that you refused to take a required COVID-19 vaccination. And I think we owe it not just to the religious, but to those people we've heard from who are mere patriots, who believe in the Liberty Clause of the U.S. Constitution, which doesn't say you have to be of a certain faith to exercise your right. You are entitled to those rights regardless of your faith, or for that matter, the lack thereof. And I don't know what the consequence to the fund will be, but either we oppose these mandates and want to stand up against them, or we want to carve out exceptions that, when scrutinized by a court, may be struck for everyone. Now, I could have made the same allegation on the last bill we discussed, that it was done cleverly and insincerely, and I don't think it would have been a stretch for me to say that, but I refrained from it because I, pursuant to the rules of this body, do not question the intention of those people offering amendments. I take every amendment as being sincerely offered, regardless of how it might appear on its face. Thank you, Madam Chair.
Representative Carmichael, then Senator Masterson.
Thank you. Pardon me. Thank you, Madam Chair. Chairman Tarwater's remarks regarding changes in unemployment law, state unemployment law, being subject to reversal or disapproval by the federal government, I think what he used the term illegal laws, is in fact a reflection ultimately of the supremacy clause contained in the United States Constitution. And as the very valid point made by Chairman Tarwater reminds us, unemployment law, employers who are subject to unemployment law are subject to federal law, and that federal law takes precedence over what we might do with respect to state unemployment laws. That's because of the supremacy clause of the United States Constitution. That supremacy clause is also effective with respect to employers who are faced with conflicting mandates between a federal law that requires federal law and regulations adopted pursuant to federal law that requires vaccinations, as opposed to what is proposed here would be a state law that prohibits mandatory workplace vaccinations. The concept is equally applicable to the employer under unemployment law as it is under the Americans with Disabilities Act, freedom of religion under the United States Constitution, etc. So the bottom line is, I hope the committee doesn't forget that we don't get to pick and choose which of our enactments are subject to the supremacy clause and which are not, because the bottom line is, under the United States Constitution, which we all revere, and which I certainly accept as the supreme law of the land, both unemployment law, ADA law, mandates, etc., are all subject to the supremacy clause. Thank you, Madam Chair.
Senator Masterson.
Thank you, Madam Chair. And let me first address that. The comments I had were not anything less than what meant to be a compliment about the cleverness. I mean, I meant that in a sincerely complimentary way. But And that wasn't even meant to question the sincerity of his desire for a particular outcome, but knowing that that outcome would potentially torpedo what we're trying to accomplish, even if it's a sincere, even believing it's a sincere desire. So that was not, so let me first apologize that that was not meant to be anything less than a compliment on the intellect. But nonetheless, without the structure, there's no way for those evaluating to tell whether if that was the reason or not, which sets up the conflict and the greater problem. And the other thing I'd like to push back on is this reading of religion, and somehow this is a class system of religious, non-religious. The truth is, every human person has some body of worship, whether you call that humanism, pick your poison that you worship. Every human has some level of that. And that's why when you read the definitions around religion, they're trying to confuse that an individual must be part of some structured religion. For example, a Catholic. You could be a good Catholic and have a sincerely held belief that a vaccine is damaging to you. And that holds the level of a religious belief because you sincerely believe that. And that is qualified under EEOC. You do not, this is not a you have to be religious in some way that we carry it in our vernacular. It's simply almost a term of art in the sense of a deeply held belief that reaches the level of a religious belief. They use that to give the context to which you believe it. It does not eliminate anybody if you don't belong to some particular church. You can have a deeply held belief that is akin to a religious belief and qualify. The structure around it is to make sure there isn't just a bunch of bad actors getting fired for some other reason and claiming this and setting up all these false claims of action. We don't want that. That is a broader consequence, and there's a big conversation around that. Do I believe you shouldn't have to jump through all these hoops? Yes, but the human condition is the fact we have to protect on all sides of that, and we have to get this portion through in a very difficult political climate. And I know where we're at, it's not going to satisfy everybody, probably not going to satisfy anybody. It's not nearly enough for some, way too much for the others, but that's why we are here, to try to find that thread through the needle and protect our citizens immediately while this all works through the courts. So again, Madam Chair, I'll leave it at that. Thank you, Madam Chair.
Seeing no further discussion, we have a motion and a second. Oh, yes, Representative Miller.
It'll be quite simple. I won't repeat everything I said. I'll repeat one, what I believe, very salient thing I said. This is one of those times when you want to say something so that later you can say, I told you so. And I will repeat, equal protection under the law, 14th Amendment to the United States Constitution, nor shall any state deny to any person equal protection of the laws. And while I'm a lawyer and admittedly not that great of one, I don't think it'll take too much of an attorney to win that suit. Thank you. I would advocate my amendment to the recommendation.
Again, we have a motion and a second. All in favor, say aye. Opposed, no. Appears to the chair that the noes have it. The motion fails. Additional discussion on 2357. Senator Warren.
Thank you, Madam Chair. I wanted to, the way that Senator Masterson explained that last kind of dilemma where we are, it's not enough for some how far the proposals go. It's too far for others. Spoken like a lawyer, I would say, because, one side always thinks they didn't get enough and the other side thinks they gave too much. But when we have to govern, we have to operate that way and look towards what is going to be a reasoned solution? And regarding the opportunity for the operation of the supremacy clause, well, you know, what is more supreme in our body of law than the First Amendment? And the First Amendment does not get to be trampled upon just because we're in the middle of some world situation that we've got to decide what to do. So I would assert that what we have proposed here in 2357 doesn't prohibit a mandate. It just requires the exemptions. It requires the exemptions to be recognized just like we do in other areas of law. So just wanted to make those comments. Thank you, Madam Chair.
Representative Miller.
Thank you, Madam Chair. I have no more discussion on this proposal, but I do just want to call to your attention before we shut down discussion. I have another recommendation when we complete the discussion on this particular one. And it's being crafted by the reviser right now.
Do we have an ETA on?
This is not the time to bring it up. Because
We've
it
got
doesn't relate to this proposal. It relates to the issue, but not this bill.
Any additional discussion on 2357 before we move on? Seeing none, we will take up Representative Miller's recommendation.
And while that's being distributed, I'll attempt to make some remarks and have those out of the way. I haven't seen this myself, but I trust the revisor's office to do their usual quality work. The intention here, and I'm one of these people that don't support mandates, regardless of whether they emanate from the federal government or state government. I believe as an employer that I have the right, subject to the laws, the accepted laws against discrimination, I have the right to set requirements of my workforce. So I do not support laws, mandates, if you will, by state government that say as an employer I can't require my own employees if I choose to be vaccinated. That being said, if I choose that route and require my employees to be vaccinated, I think I should be responsible should they incur injury. And what my amendment would do is simply say that if that is the case, and if it's the case that I'm requiring independent of any other government mandate, I'm not talking about these folks under the federal mandates right now that are required to comply. I'm talking about an employer who, independent of that, requires its employees to be vaccinated subject to termination, that in the case of injury to those people, if it happens, and I don't agree, by the way, with Senator Thompson's numbers in terms of the direct consequence, but that's a different debate. If you are injured as a consequence of a forced or induced or coerced vaccination, the person requiring that should be held responsible. So that's what this amendment does, is it does allow for recovery in those cases of injury. Jason, did I misspeak on the amendment? So it's not really an amendment. This is a separate proposal. And I would offer this to the committee and ask that we accept it as a recommendation to the special session. I'd stand for questions.
We have a motion. Any second? Senator Petty, seconded by Senator Petty. Discussion. Representative Tarwater.
Thank you, and thanks for bringing this before us. Employer, what about schools? And I mean, if they start requiring a vaccine for students and they have adverse reactions, is that any part of this bill, or can it be added?
No and yes.
Thank you.
Any further
and by the way, I would not oppose such an extension.
Any additional discussion? Representative, you may close.
I move my recommendation.
We have a motion and a second. All those in favor say aye. Opposed, no. Motion carries. Seeing no further business before the committee, I want to thank everyone for their participation. Thank you, staff. We are adjourned.